잠시 후 2시부터 컨퍼런스가 시작되겠습니다. 컨퍼런스에 참석하신 분들께서는 회의장 안으로 입장하여 주시기 바랍니다. Good afternoon, ladies and gentlemen. Today's conference will begin at 2 p.m. Please enter the conference hall and take a seat. Thank you for your cooperation. 잠시 후 2시부터 컨퍼런스가 시작되겠습니다. 컨퍼런스에 참석하신 분들께서는 회의장 안으로 입장하여 주시기 바랍니다. Distinguished guests, The opening ceremony of today's conference will begin in a few minutes. Please enter the conference hall and take your seats. 본 행사장에서는 참가자 여러분의 편의를 위해 동시 통역기가 제공됩니다. 한국어는 채널 1번, 영어는 채널 2번이니 참고 부탁드립니다. Simultaneous interpretation service will be provided for the entire conference. So please take your receivers and select your preferred language. Channel 1 is in Korean and Channel 2 is in English. 아울러 행사의 원활한 진행을 위해 소지하고 계신 휴대전화의 전원을 꺼주시거나 진동 모드로 전환해 주시면 감사하겠습니다. 또한 코로나19 예방을 위해 불편하시겠지만 행사가 끝날 때까지 마스크를 반드시 착용해 주시기 바랍니다. As a courtesy to other participants, please turn off or put your cell phones on silent mode during the entire conference. As a precaution against COVID-19, we would like to ask you to wear a mask. Thank you.
1948년 12월 10일 유엔 총회는 세계 인권 선언을 채택하며 인권의 날을 지정하였습니다. 인권은 모든 사람이 차별 없이 누리는 보편적인 권리이며 모든 국가는 인권을 보장할 책무를 지니고 있습니다. 국경을 넘어 세계적인 과제인 인권 보장 및 증진. 노동인권도 예외가 될 수 없습니다. 노동자 및 사용자는 어떠한 차별도 없이 사전 인가를 받지 않고 스스로 선택하여 단체를 설립하고 해당 단체의 규칙만을 따를 것을 조건으로 하여 그 단체에 가입할 수 있는 권리를 가진다. 국제노동기구 결사의 자유 및 단결권 보호에 관한 협약 제2조 2022년 4월 20일 국제노동기구 기본협약인 제87호 결사의 자유 및 단결권 보호 협약과 제98호 단결권 및 단체 교섭권 협약이 대한민국에서도 효력을 갖게 되었습니다. 국제노동기구 협약 발효 후 법원의 재판에서 무엇이 새로운 쟁점이 될까요? 사법정책연구원은 현실과 규범, 실무와 이론을 아우르는 체계적인 연구를 통해 미래의 사법부가 추구해야 할 바람직한 모습을 만들어가고 있습니다. (2022년) 사법정책연구원은 국제노동기구와 유엔 인권 최고 대표 사무소와 함께 국제인권법 및 노동법 전문가들을 모시고 국제노동 기준 및 국제인권법 적용에 관한 쟁점과 과제를 고민합니다. 인간으로서 가지는 보편적 권리, 인권. 모든 노동자가 누려야 할 인권, 노동권. 이제 새로운 모색을 향해 출발합니다.
Good afternoon, distinguished guests, ladies and gentlemen. Welcome to the 2022 JPRI International Conference. I'm Dr. Hyunjung Song, a professional researcher of JPRI. It is a great honor for me to serve as Master of Ceremonies at today's conference. This conference is co-hosted by the Judicial Policy Research Institute, the International Labour Organization, and the Office of the United Nations High Commissioner for Human Rights. The main topic of today's conference is International Human Rights and Labor Standards, Challenges for the Judiciary. Over the course of 2 days, we will discuss application of human rights treaties and future challenges, and ratification and domestic implementation of the ILO Fundamental Conventions. I hope that this conference will provide a valuable forum for experts to engage in in-depth discussion about the issues and challenges that affect courts' approaches to applying international labor standards and human rights law. On behalf of the organizers of the conference, I would like to express my sincere gratitude to all of our distinguished guests for taking time out of your busy schedules to join us. Also, I would like to welcome everyone who is joining us today on YouTube. We are live streaming the entire conference on the Judicial Policy Research Institute channel on YouTube for those who are unable to attend in person. This conference will offer simultaneous interpretation. For on-site participants, please take your receiver and select your preferred language. Channel 1 is in Korean and Channel 2 is in English. We'll now commence the 2022 JPRI International Conference. It is my great pleasure to introduce our host for this conference, Mr. Gi Tae-hong, the President of JPRI. He will make the opening remarks. Please welcome him with a big round of applause.
존경하는 대법원장님,
Honorable Chief Justice of the Supreme Court of Korea, former President Sang Hyun-song of the International Criminal Court, former Justice Il-won Kang of the Constitutional Court of Korea, and ladies and gentlemen, and distinguished guests, thank you very much for joining us today. I would also like to offer my gratitude to Honorable Judge Mr. Lubarda of the European Court of Human Rights, who sent us a recorded congratulations message for today's event. It is a great honor for the JPRI to hold an international conference today together with the International Labor Organization and the Office of the United Nations High Commissioner for Human Rights. Thanks to their special attention and cooperation, it is possible to hold this conference successfully despite difficult circumstances. Thus, I would like to offer my sincere gratitude to the Director General of ILO and the High Commissioner of UNOHCHR, as well as all other members belonging to these international organizations who are concerned with this conference. These days, human rights have become a matter of common interest for the international society, going beyond each country's domestic laws. As the prominent international organization symbolizing international cooperation for human rights, the UNOHCHR has been actively operating in various places around the world. Also, for more than 100 years since its establishment in 1919, the ILO has been working constantly to establish international standards in the fields of labor laws and labor rights as a part of human rights. Having achieved both economic development and political democracy, which is a rare example after World War II, the Republic of Korea has been turning its attention towards harmonizing domestic laws with international human rights norms since the beginning of the 21st century. As part of such efforts, it ratified in 2021 Freedom of Association and Protection of the Right to Organize Convention, number 87, and the Right to Organize and Collective Bargaining Convention, number 98 of the ILO, respectively. As these agreements take effect in April 2022, significant changes in the current domestic laws concerning the collective labor rights, namely the relationship between workers' organizations and employers, including their organizations as well, are expected. Therefore, as a policy research organization that represents the Judiciary of the Republic of Korea, the JPRI has prepared this international conference jointly with the two international organizations that represent human rights laws and labor standards, with the purpose of discussing possible influence with the newly concluded ILO fundamental conventions based on the international human rights system may have on the Korean labor laws. This conference will be held for 2 days. On the first day, namely today, we will first have an overview of the international human rights systems in general, and then the various legal issues regarding the interpretation and application of international human rights treaties will be examined. On the second day, which is tomorrow, discussions focusing on the contents of the ILO's fundamental conventions will take place. In particular, we intend to deliberate on domestic labor law issues arising from the conclusion of the fundamental conventions. Last, a final plenary session is planned that will cover all matters discussed during the conference. I hope that the participation of various experts in human rights law and labor law from home and abroad in this conference will make a valuable contribution to the development of legal practice in courts and the improvement of human rights in the Republic of Korea. For the courts to fulfill their role as the last bastion of human rights, the JPRI will do its best to conduct the necessary research. Last, I would like to offer special thanks to those from the ILO who traveled a great distance to attend this conference, namely Mr. Tim DeMeyer, Senior Advisor on Standards Policy in the ILO Department, and Ms. Curtis, Deputy Director of the same department and Chief of the Freedom of Association Branch, and Mr. Bodenot, Coordinator of the same department. I would also like to thank Mr. Heenan, the representative of Seoul Branch of UNOHCHR, and Dr. Kuntz from Collegium Helveticum. Also, I would like to offer my deepest gratitude to the experts who accepted the roles of moderators, presenters, and panelists, as well as all who planned and arranged this conference. Thank you.
Thank you, President Hong, for the opening speech. This time, the Honorable Myung-Soo Kim, Chief Justice of South Korea, will give us a welcoming address. Please join me in welcoming the Chief Justice of the South Supreme Court of Korea.
존경하는
Distinguished guests from home and abroad, on behalf of the Korean Judiciary, I would like to offer my sincere congratulations on the international conference, which is being held today by the Judicial Policy Research Institute under the Supreme Court of Korea, jointly with the ILO and the UNOHCHR. And I am delighted to welcome all those who have attended this conference despite their busy schedules. I would like to also express my sincere gratitude to Mr. Song Sang-hyun, the former president of the ICC, for visiting in person to offer congratulations and encouragement on today's event. Moreover, I would like to offer my gratitude to the Honorable Judge, Mr. Rolodva of the European Court of Human Rights, who sent us a recorded message of congratulations. Every man and woman, regardless of his or her race, nationality, gender, or wealth, enjoys the same rights as human beings, namely the human rights. On reflection of the past scenario, serious infringements on human rights during the two world wars, the United Nations and other international organizations have built elaborate legal systems to guarantee human rights. Furthermore, in some regions of the world, in particular in Europe, supranational human rights courts are successfully established. The principal mission of Korean courts is the interpretation and application of the domestic laws of the Republic of Korea, and just as other state institutions do, they have an obligation to confirm and guarantee the human rights of the people. Therefore, it is necessary for judges who are in charge of specific cases to pay attention to the internationally settled human rights protection standards and systems and to study them continuously along with the Korean domestic laws. The Republic of Korea ratified in 2021 Freedom of Association and Protection of Rights to Organize Convention number 87, and the Right to Organize and Collective Bargaining Convention number 98 of the ILO. Accordingly, these conventions have come into effect as domestic laws since April of this year. Therefore, judges must have interest in the contents of these conventions and make efforts to ensure their appropriate interpretations. In 2018, the JPRI had already published a report that examines the possibilities of the establishment of an Asian Regional Court of Human Rights. Also, in 2020, it reviewed the cases in the Korean courts in which international human rights treaties were applied in domestic legal disputes. Furthermore, in April 2022, it published a report that comprehensively dealt with labor standards issues in relations to the aforementioned ILO conventions concerning the freedom of association. Based on such achievements, the JPRI has managed to hold today's conference together with prominent international organizations in the fields of human rights and labor standards. I would like to express my deepest gratitude for the efforts on the part of JPRI. Wars, economic crises, and the rise of authoritarianism in various countries around the world are once again threatening human rights of individuals. I hope that the presentations and discussions by experts of human rights and labor standards from home and abroad who have attended this conference will contribute to a more effective guaranteeing of human rights in the Republic of Korea. Lastly, once again, I would like to express my deepest gratitude to all the guests who have taken the time out of their very busy schedules to attend this conference on behalf of the Judiciary of the Republic of Korea. And thank you to Hong Ki-tae, President of JPRI, and all those who have made this conference possible. And I would like to leave you by wishing you the best of health and happiness. Thank you very much.
Thank you, Chief Justice Kim, for your welcoming statement. Next, I would like to introduce Mr. Sang Hyun-song, former President of International Criminal Court, to deliver his congratulatory remarks. Please welcome him with a warm round of applause.
우선 오늘
First of all, I would like to offer my sincerest congratulations to the Judicial Policy Research Institute, JPRI, the brain of the Supreme Court, for hosting this significant international conference today, and for the presentations and discussions that will take place over 2 days under the timely theme of international human rights and labor standards, challenges for the judiciary for 30 years since the end of the 1970s. Now, for the 30 years, I was deeply involved in committees that constantly worked to improve and internationalize Korea's judicial system, advised on the construction of the new Supreme Court building, and appointed justices of the Supreme Court. Through those involvements, I feel quite proud that I could contribute to maintain judicial independence amidst a modern political landscape with many radical changes. And that is why I am quite pleased to give congratulations to the JPRI's International Conference. Each time I contact foreign organizations that attach great importance to democracy and constitutionalism, I always comment on how sound and independent the Korean judiciary is, and how talented and outstanding Korean judges, most of whom are my pupils, are. I also emphasize their world-class attitudes and professionalism in trial. Even after having taught at dozens of top-class law schools around the world, my assessment of these judges remains unchanged. In fact, despite the criticisms and complaints by many, there are very few examples of a country where its judiciary, created after World War II, has attained as much independence from the superior authority of its administration as was the case in Korea. That is why I am always proud of Korean courts, which are being filled with such outstanding personnel. Moreover, I believe a sound and impartial judiciary branch is the true and ultimate investment incentive for foreign investors. This is why I have even written a column encouraging foreign investors to trust the Korean courts and invest aggressively in this country. Also, I am pleased to say that when I was entrusted with digitalizing the newly created International Criminal Court and was establishing an internal operating system, my experience working with the Supreme Court of Korea came in very handy. The judiciary is normally viewed as conservative because it usually observes the rules and does not take any great risks. And there are many people who are frustrated with the precedents that they make. Still, the courts are not under any obligation to take a stance of judicial activism each time. But the Korean judiciary is advanced and highly praised for its efforts, like today, when it quickly manages urgent topics. Holding an international conference, professionally reviewing the newly ratified labor convention, and discussing ahead of time how advanced norms will be applied during trials is a quite useful, forward-looking attitude that corresponds with international trends and is one that is highly praised. I truly wish for the success of this international conference that would sort the correlating labor law issues raised after the National Assembly ratified the ILO Fundamental Conventions, scrutinize the impact the new norms would have on the economic activity in Korea, and ultimately bring stability in the law and order before any confusion can come about. Historically speaking, in 1945, when the United States military government briefly controlled Korea, high standards of American labor laws continued to be enacted and promulgated in Korea that could not still move away from being an agrarian society, which caused a lot of confusion and anxiety for a long time. Even after the Republic of Korea government was established, traces of that impact remained. The labor laws at the time were out of touch with the labor realities of Korea. Judges at the time were concerned for a long time about how the labor laws at the time should be interpreted and applied for legal stability when there was a major gap between the laws and reality, and were concerned about how the majority of the people could accept these laws. But ultimately, through wise interpretations, they could close the gap between the laws and reality without greatly diminishing business activity, and they greatly contribute to the stability of law and order. This time, the ILO conventions ratified by the Korean government contain many advanced regulations which have in fact evoked concerns from certain concerned parties. However, at this international conference, armed with foresight and a sense of fairness, I am sure that the Korean judges will rationally harmonize different interests, such as the significance of the new international labor laws and present situation of the domestic economy being thrust into economic recession, domestic business activities being clipped at the wings, and the demands of the very self-assertive labor unions. And this international conference will create a stepping stone upon which Korea would make a new leap toward being a labor advanced nation. Thank you.
Thank you, Mr. Song, for your generous remarks. This time, we are going to watch a video message of congratulatory remarks delivered by Mr. Branko Lubarda, a judge of the European Court of the Human Rights.
Dear President of Judicial Policy Research Institute, Mr. Hong, dear Chief Justice of Supreme Court of Korea, Mr. Kim, dear Director General of the International Labour Organization, Mr. Umbo, dear United Nations High Commissioner for Human Rights, Mr. Turk, dear fellow judges and distinguished academics, it is my honor and pleasure to convey to you, on behalf of the European Court of Human Rights, our very best wishes on the occasion of your international conference. You have chosen an extremely topical subject. An independent and strong judiciary plays a crucial role in maintaining democracy and the rule of law. One of the key features of the European human rights protection system is its subsidiary character. Under the subsidiarity principle and the principle of shared responsibility, member states and national judges are first and foremost responsible for the effective implementation of European Convention on Human Rights and its protocols. Dialogue between the Strasbourg Court and the national judicial systems is fundamental to the Convention system. In that sense, the Superior Court networks brings together community of judges who have a central role to play implementing the principles and value of European Convention, which we have been sharing and defending for 70 years. The network, now covering 103 courts from 44 states, is a unique tool facilitating the privileged transmission of knowledge to superior courts in the sphere of human rights. It has recently been externalized to enhance further dialogue, extended it to academia and civil society. The Strasbourg Court has developed dialogues with other international human rights courts, Inter-American Court on Human Rights and African Court on Human and People Rights, with the Court of Justice of European Union, and with specialized supervisory bodies monitoring fundamental labor and social rights. The interpretation of the Convention and its protocol integrates essential aspects of the labor and social rights, a constant interplay between the norms of human rights law included in Convention and the norms of international labor law, which are mainly found in the ILO conventions. As a result, the Strasbourg Court allocates an indirect legal effect to the treaties which would otherwise not be justiciable. The European Convention on Human Rights, seen mainly as an instrument for ensuring protection of civil and political rights, has been given an important incentive by the Strasbourg Court case law, giving it more socially oriented dimension by permanently extending the scope of applicability of both absolute and qualified rights to cover certain aspects of labor and social human rights. The ECHR case law has provided for direct and indirect protection of certain aspects of labor and social rights. Indeed, number of civil and political rights laid down in the Convention and its protocols extended to the sphere of labor and social rights as a result of the interpretations given by the Strasbourg Court, in line with the living instrument doctrine and the credo that all human rights are universal, indivisible, interdependent, and interrelated. This may be illustrated inter alia by making reference to two of our most recent pending grand chamber cases, Communauté Genevoise d'Action Syndicale, relating to the blanket ban on public meetings for 2.5 months at the start of the COVID-19 pandemic, and Quimper versus Germany concerning the prohibition on teachers with Silver 7 status from going on strike. Dear Presidents Hong and Kim, dear organizers and participants, once again, many congratulations for organizing the international conference and all my good wishes for the great success of this impressive international event. Si vis pace, cole justitia.
Thank you, Judge Lubarda, for an inspiring message. This brings us to the end of the opening ceremony. Before we start the first session, we will have a time for taking commemorative photos. Since there is a slight delay, first session of the conference will begin at 2:40. Thank you. Session 1 of the conference is going to start in a moment. I would like to now invite all of the speakers, panelists, and the moderator of the session number 1 to the stage. Thank you. We'll now have session number 1. Before we begin, I would like to inform online participants to leave their questions in YouTube comment section during the conference. Please leave a comment if you have any questions for the speakers. And there is also a real-time viewing certification event going on. Please see the More from YouTube section for further information. The topic of session number 1 is International Human Rights System and the Role of the Courts. The moderator of this session is Mr. Il-won Kang, a former Justice of Constitutional Court of Korea. He graduated from Seoul National University and passed the National Bar exam in 1981. He served as a judge for 27 years. During his legal career, he received an LLM from the University of Michigan and served as an expert advisor to several judicial reform committees in Korea. In 2012, he was appointed to the Constitutional Court as one of 9 justices and became a member of the European Commission for the Democracy. In 2018, he retired from the court. He is now the managing partner of the law firm K1 Chamber LLC. Please welcome him with a big round of applause.
Thank you for your kind introduction. And before I start the first session, I'd like to extend my sincere gratitude to all the members of the JPRI who arranged this wonderful conference. And also, I'd like to thank you for all the participants from in here and through the YouTube. And since we are just behind the schedule, so I'd like to jump into the first session. As the moderator, the speaker said, the theme of today's conference is the application of international human rights treaties in local courts. In the first session, we will discuss international human rights system and the role of the court. The speakers from the ILO and UNOHCHR will share their deepest knowledge on the international human rights protection system with us. Now let me introduce 2 speakers and 2 panelists for the first session. The first speaker is Mr. Tim DeMeyer. Mr. Meyer served as International Labor Standards Specialist for East Asia and the Pacific. and also Director of the Country Office for China and Mongolia. Now he is working as Senior Advisor on Standard Policy with the International Labor Standards Department of ILO. Please give Mr. Meyer a big round of applause. The next speaker is Mr. James Heenan. He is a representative of UN Human Rights Office, Seoul. Mr. Heenan assumed his duties in Seoul this October. It means he is a newcomer of this Seoul. Before joining the office in Seoul, he was the head of the OHCHR office in the occupied Palestinian territory. He has worked with OHCHR for 20 years. Please welcome Mr. Heenan with a warm applause. Also, we have two panelists here. Let me first introduce Professor Jiu Song. Ms. Song is an associate professor of political science and international relations at the Seoul National University. She holds a bachelor's degree in sociology from Seoul National University, a JD from Harvard Law School, and a PhD in philosophy from Harvard University. Would you give Professor Song a big applause? Now, another panelist is Professor Ju-Young Lee. Ms. Lee is Associate Research Professor at the Seoul National University Human Rights Center. Professor Lee currently serves as President of Korean Association of Human Rights Studies. She is to serve the UN Committee on Economic, Social, and Cultural Rights from January 2023 to December 2026 for 3 years. Please give Professor Lee another big round of applause. Now, finally, we start the first session. At first, Mr. Tim DeMeyer will make a presentation on the future of international labor standards as part of UN rights norms and standards. Mr. Meyer, you have 30 minutes. Floor is yours.
Thank you very much, Chair. And first of all, apologies if my voice comes across a little muted. I had an unexpected nosebleed over lunch, and thanks to the excellent services, occupational safety and health services, as we call it in the jargon here, I have been fixed sufficiently to participate in this distinguished panel. I bring also to you the very warm greetings on the occasion of Human Rights Day, which we celebrated on Saturday. The very warm greetings of Director Corinne Varga, the Director of the International Labor Standards Department in Geneva, who absolutely had wanted to be with us, with you today, but unfortunately could not make it because of a very important matter that at some point will certainly also be of interest to Korea, just like all our other member states, and that is the consultations we are having on a mechanism, activating a mechanism for the interpretation of international labor conventions. So according to the ILO Constitution, the interpretation of standards is assigned, mandated to the International Court of Justice, or should our Executive Council so wish, to a tribunal that would be set up specifically for that purpose. That has never happened up to this point. We are now approaching a point where that may happen, and these consultations are obviously very important. This is the reason why she cannot be with us. I have quite a number of slides, but many of them, and I will not cover in extenso. Let me start perhaps with a number of values that arise from our constitution, from the mandate that we have received as an organization from the international community, and which are important in understanding the ILO normative system. Then perhaps very briefly take you through some of the mechanisms that we have for making that normative system function. I would have some, not too many, because it's an issue that we will come back to, some reflections on what is sometimes called the self-executing power of provisions in international labor standards. And then, as the agenda also provides, in time permitting again, some reflections on what I would call the future of international labor standards, given, of course, that international labor standards have to evolve just like the world of work evolves. We are probably at a very critical point in time globally, with very fast changes to the world of work. And there are a number of things that the organization does in order to make sure that its standards stay in line with this. But so first, and this is basically every presentation these days we make on this topic. You are probably already aware that the United Nations has 193 member states. It is an intergovernmental organization, and the ILO was the first specialized agency in 1946 through its international labor standards, making a contribution to the central objective of the United Nations, which is, of course, to maintain peace and security, but also to advance development, as well as the third pillar often referred to, the promotion of human rights. The ILO is a specialized agency, but operates on the basis of its own constitution, and very markedly and often forgotten is the fact that decisions at every possible level up until the highest level are taken, and not just by governments, but by representatives of workers' organizations, trade unions, as well as employers' organizations, which immediately raises the question, A, why is this? And the other question, who invented the system of international labor standards? Because that is something that will bring us back to a key value of the organization that actually President Kim was just referring to in his opening remarks, and I took good note of that. Now, this is a very distinguished audience, so I'm not going to put anyone to the test here, but just think for a moment whether you personally feel or know which of the three ILO constituents, as we call them, governments, workers, employers, which of the three has actually invented the notion of standards? Who has come up with the idea? 1, 2, 3. Okay, everyone has an idea. Now, usually when I ask that question, the answer is almost identical always. You will have well over half that will say the organization and its system of standards, because that was what the organization originally, 1919, was set up to do. Over half of our audience will say trade unions, workers' organizations, because the ILO is there for trade unions, which is a conception and indeed a misconception that you very often hear. Then there is a good part of the audience that will say governments, because at the end of the day, it's governments also participating, governments are important, governments take care of the public interest, so it must be governments. And then there's usually one or two voices that will say employers. And the answer is actually employers. It's employers that originally came up, not 100, but about 200 years ago, with the idea that if serious business needed to be made of improving what at the time were very often inhumane conditions of work, then they had to make sure that A, they would be able to continue to do their business, very important, but also they needed to make sure that those businesses they were competing with, and today that also means globalization, other countries in the world, that they do more or less the same, which points to the development of a system of standards. You needed to put in place standards, which everyone, more or less, to the extent possible, was able to, would be able to comply to. The idea was then, well, although employers realized this, they said, we cannot do this ourselves, so we need to give this mandate to an organization, the government, that takes care of the public interest, that is also in charge of enforcing, promoting compliance. And this is how we ended up with a system of international labor standards. But what is very important in there, and I quote here what President Kim said in his opening remarks, the courts, who of course play a very important role in making sure that these standards matter, the courts, through wise interpretation, were able to close the gap between law and reality, which you could read as between the law on paper and the aspirations of people, without unduly interfering with business. And this latter point is very important, and which underlies also very much the ILS system, and that is that it was from the very beginning realized that in order to maintain wealth creation, to be able to tap the innovation of employers, it would be very important that they are able to maintain the property rights over the means of production, but always balanced with the requirements of what we call social justice. And so it is that 100 years after 1919, the ILO Centenary Declaration for the future of work, that means not just for the past 100 years, but what is going to come next, that the setting, promotion, ratification, and supervision of international labor standards remains of fundamental importance to the ILOs. The setting, the promotion, the ratification, and the supervision. And we'll have sessions as we proceed. We'll have sessions that deal more specifically with the questions around ratification. Okay. The Universal Declaration of Human Rights is per se a little bit younger than the ILO Constitution from 1948. But there the question, the key idea was that we need to have, and the ILO, through its ILO standards, needs to make a contribution to that. We need to have as fundamental values for maintaining peace and security in the world, we need to have democracy, we need to have rule of law, equality of everyone before the law, and with the purpose of realizing human rights. Because without respect for human rights, we will eventually end up with a situation of instability, social instability, and as the Universal Declaration calls it, rebellion against tyranny and oppression. So you could say that international labor standards, if you summarize it, in the interest of social justice, give expression to human rights at work, some of which are expressed in the Universal Declaration and codified later in the core human rights instruments, most immediately 1966, the International Covenant on Economic, Social and Cultural Rights, as well as on the International Covenant on Civil and Political Rights. International labor standards have to be understood as giving expression, setting further standards, involving workers and employers with respect to those standards, but sharing very much the very same objective. Applying a rule of law which guarantees a safe space for social dialogue, and this is very critical. Sometimes the rule of law is misunderstood as just a blind application of law and legal systems. The rule of law means that everyone who operates within a country that has a legal system is subject to that legal system. No organ, no individual, no organization can place itself above the law. But in order to realize the objectives of social justice, which I'll come back to in a minute, it is also essential that within the rule of law, there is a safe space for social dialogue. There is a safe space for workers who, because of economic reasons, in a market economy, are in an unequal power relationship. There must be a safe space for them to advance their interests, to advance their rights. This is actually a principle that is explicitly also included in Convention 87, which of course on freedom of association and protection of the right to organize, which Korea ratified in 2021. The purpose of all of this, and these are words from the Constitution, is providing people the freedom to live in dignity in open market economies. And here I come back. The system originally was invented by employers in order to maintain the market economy, the principles of the market economy, in order to maintain the principle of being able to create innovation and wealth, which is a important, very important, crucial factor in any healthy society, but always in balance with and not overriding the principle of social justice. Social justice, which is a term that you find throughout ILO constitutional documents, is nowhere specifically defined, but of which there is a reference in one of the more recent declarations, in which can usefully be understood as an economic, social and political situation which delivers to all people, and here are the key words, a fair share of the wealth they directly or indirectly help to generate. But it's very important here is the word fairness, and President Kim also mentioned it in his opening remarks. With foresight, the courts acting with foresight and a sense of fairness. Fairness means not perfect. We are not pursuing a perfect sharing of the wealth with the standards that we have, but what we pursue is that eventually is that there is a balance found between what I said earlier, if you wish to express it in human rights, the right to property over the means of production on the one hand, and the rights of the ability of and the freedom of people to live in freedom and dignity. That notion is also increasingly, I'm not going to elaborate it here, but that notion is increasingly also recognized outside the sphere of what we call public international law, the relations between states, but it is also increasingly recognized with respect to the activities of businesses. And that's a field that's been very much in development. In 2011, the United Nations developed the guidelines on business and human rights, with very specific elaborations of the responsibilities that business had with respect to human rights, including the human rights as a minimum, the human rights expressed in international labor standards. And these are very specifically to respect human rights. That means prevent, mitigate, and address human rights issues. Now, all of this is important because, particularly important for Korea, which obviously is a leading economy, a leading market economy in the world, and because it is a country that has gone through a lot of pain, I think, which is fair to say, in gaining democracy. So the notions of democracy, combining that with the maintenance of the benefits of an open market economy, quite naturally lead to a developed sense of social justice, the balance that need to be found, and how international labor standards can help this forward. So these are some of the values that underlie the system, and I can be then really a little bit quicker with the basics on the technicalities. International labor standards take two forms: conventions, occasionally accompanied by a protocol, and recommendations. The difference being that conventions are there when countries are ready to ratify, to undertake obligations. Protocols the same. Recommendations provide additional guidance, cannot be ratified, but in a sense are of an equal authority, given that they are adopted by the International Labour Conference, governments, workers and employers from all over the world, according to a process that is nearly identical as for the convention. So the two are very much complementary. If you look at the figures, the ILO having been in operation since 1919, we have today 190 conventions and 206 recommendations. That's a lot. Not all of these, in fact, formally speaking, only a minority of these today are considered up to date. That means fully relevant, fully operational for the world of work, the economy that we live in today. I'll say a little bit later about what the organization is doing with respect to the other ones. But it's very important, obviously, that when you consider ratification today, that you do that with respect to those standards that are fully up to date. 190 conventions, all of them are legally speaking equal, but given that, in the context of social dialogue, moving social justice forward, although all of these instruments are legally identical, politically they are not. It's a little bit a question of all animals being equal, but some more equal than others. So, particularly within the context of the challenges that globalization have established, the decision was taken in '98 to say, well, there are a number of fundamental principles that even when countries have not ratified the conventions concerned need to be respected. Today we have 5 of those principles, and the most significant, and that's not me or anyone else saying that. These are constitutional documents saying that. The most significant of those is freedom of association and collective bargaining. It is the enabling principle, the enabling right par excellence. You cannot have social dialogue moving social justice forward unless there is a full respect for freedom of association and collective bargaining, realized by the rule of law, but also enabled by, empowered by the rule of law. Again, this relationship that you have between the two. The elimination of forced labor. In a market economy, labor is operationalized, if you wish, on a contractual basis. So force in order to extract labor from a person is antithetical to that. Elimination of forced labor, fundamental principle. Abolition of child labor. Child labor undermines the future, any future of social justice. Elimination of discrimination at work. And since June of this year, the protection of a safe and healthy working environment. Basically, safety and health being a matter of, unfortunately, still in many cases of life and death, being a matter that absolutely needs to have a much higher place on the political agenda than it currently has. Very quickly, there are also 4 conventions that are considered governance conventions. They deal with again, fairly fundamental principles. Employment policy is what the state needs to do in order to realize what is, in the human rights context, called the human right to work, Article 6 of the International Covenant on Economic and Social Rights. Labor inspection, which deals directly with the enforcement and therefore with the rule of law and the protection that labor law provides. Tripartite consultation, decisions being taken with the full participation of employers and workers. So these are governance conventions that are also by the ILO very much proposed for universal ratification. I'm not going to elaborate on this, but some of the ideas that I explained, and here you have a number of hyperlinks, are laid down in a number of declarations, basically instruments of constitutional importance to the ILO. Okay, I am going to skip the overview of the human rights bodies in the interest of time, and given that I have my good colleague here who will certainly tell you a lot more, but you'll see in the presentation, this is just highlighting a number of the human rights as you will find them codified in the 2 international covenants, and then in a non-exhaustive fashion listing some of the conventions that are immediately relevant, that give further expression within the world of work to these human rights that are expressed. This is just an illustration of how the 2 really are very complementary to each other. I have to say a few words about the fact that the ILO does not only set standards, does not only promote standards, does not only have register ratifications, it also supervises the application, and for that it has 2 systems, a regular supervision, and this slide is not correct. I corrected it in the meantime, and I don't think it's reflected in the syllabus that you have with you. The regular supervision is basically 2 bodies: the Committee of Experts on the Application of Standards, meeting once a year, independent experts supervising the application on the basis of reports from governments, possibly complemented by observations from trade unions and employers' organizations. Every 3 years, in principle, for the fundamental and the governance instruments, and 6 years for the so-called technical instruments. Then the special procedures will also have a number of complaint-based procedures. Again, very quickly, there's 3 of them. Governing Body Committee on Freedom of Association, which Korea is very well familiar with, I think. It's a committee of the ILO's Executive Council, the governing body. It's tripartite in nature. Examines complaints specifically with respect to freedom of association and collective bargaining, even when the conventions are not ratified. Its recommendations are not legally binding, but nonetheless very authoritative. And then there are 2 constitutional complaints procedures that pertain to situations where conventions are ratified, Article 24 of the Constitution and Article 26 complaints in exceptional serious cases where the governing body is basically asked to consider whether it should set up a commission of inquiry to investigate certain complaints further. I will leave it at that as far as the an explanation of the supervisory system is concerned. Sometimes the question is asked, and I think that's particularly important for the work of the judiciary of courts, are international labor standards considered self-executing? That means basically what sort of use can you make of international labor standards? And then one of the immediate questions is, can we take international, are they meant, are they devised in order for courts so that they can immediately take in international labor standards and come to a decision in a particular dispute? The background, of course, is, and I singled this out in the case law coming from, I believe in this case it was the Constitutional Court, a case of 2003, where the position essentially was, well, if we ratify conventions, then according to Article 6, they take their place within the national legal order. It's a monistic system. But we wouldn't go as far as saying that this automatically means that these ratified instruments supersede laws that exist in terms of declaring them unconstitutional. So a little bit of an unresolved situation where one of the judges, and I think this is important, basically said, well, maybe that is so. Maybe we don't immediately need to go as far as saying that because of a ratification, because we are a member of an organization, because we have international labor conventions that we are committed to. But we have to make an effort to make sure that these standards, including the recommendations of the supervisory bodies, serve as an important standard when evaluating the constitutionality. And I think that's a very important starting point. As far as the organization is concerned itself, we're not necessarily, we don't, as an organization, we don't really have a position on whether provisions should be self-executing or not, because the notion of self-executing is something that is, in our view, determined at the national level. The ILO Constitution obligation is you have to make sure that when you ratify a standard that you give effect. You need to take the action as is necessary to make effective the provisions of the convention. If you feel that with respect to a particular provision, self-executing is the solution, so be it. Otherwise, there are other ways that you can bring international labor law into play. You can use it as a guide for interpretation to establish a jurisprudential principle there where the law is silent on a particular issue, or to strengthen a decision based on domestic law, again where the legal system allows for the court to fill in gaps within the national legal order. What is important and what I would like to draw your attention to, if there are questions of this nature where there is a doubt as to whether as to how to exactly understand a convention and see if it can be used for interpretative purposes or to fill in a gap in law, you can ask for informal opinions from the office. I'm going to conclude with a quick overview. I'm not going to talk about the standards review mechanism, except to say that the ILO is currently operating a mechanism where it is reviewing a significant batch of international labor standards and is drawing conclusions as to whether these standards are up to date, outdated, or require further action, potentially involving revision of standards. So questions in this respect, and we know there are many, please do not hesitate to be in touch with us. I just wanted to conclude by bringing to your attention and also looking forward in terms of potentially new standards needed by a changing world of work. What we have in the process of consideration are a number of items, and you'll see them appear presumably between now and 2030, the Sustainable Development, the end of the Sustainable Development Agenda. One standard has already been adopted: violence and harassment in the world of work. There will be more standard setting around a very quickly evolving area: safety and health, prevention with respect to new chemicals, guarding of machinery, new technology in terms of ergonomics and manual handling. There should before long be a standard setting process, but that's not yet agreed, around decent work in the platform economy. And there are discussions around questions of whistleblower protection, something that is very important in the fight against corruption and protection of workers' personal data in the digital era. I will conclude here just to say that our work is far from done when it comes to work around standards, whether it is promoting ratification, whether it's setting new standards, or whether it's indeed supervising obligations that are freely undertaken through ratification. Thank you.
Thank you very much, Mr. Meyer. He explained the role and the future of the ILO international labor standards as UN human rights norms. And because of time limits, his wonderful presentation should be shortened. So please refer his excellent PPT documents, which was prepared here. It is very instructive and informative. It will give you some more information and instruction. And now we are moving to the next speaker, Mr. Hinan. Mr. Hinan will introduce the international human rights system and the role of the courts. Mr. Hinan, you also have 30 minutes. Floor is yours.
Thank you very much, Mr. Chair, and thank you to JPRI for this event and for co-hosting with the ILO and us in the Office of the High Commissioner for Human Rights. Annyeong haseo to everyone here in the audience. So I'm here as, my job in Seoul is as head of the office here in Seoul, but I'm here representing our headquarters from Geneva for this session, based on my past experience as well. My colleague from the ILO, Tim, has covered a number of areas of the ILO architecture. I'd like to focus on the human rights treaty system, with an emphasis on how it relates to labour rights, but particularly how it's relevant to national courts in the Republic of Korea. Beyond human rights, these sort of lessons are also useful for interpretation of other conventions in courts. Very briefly, the international system, I don't want to go into it too much detail, you can read this in books, but one of the things about the UN system, the first thing is that it's quite confusing, and that's because it grew organically. It didn't grow at one point, it didn't exist at one point, it grew organically, so it is quite confusing to understand. Even the slide I have on the screen is not entirely correct. I expect someone, maybe one of my ILO colleagues, to tell me it's incorrect. The trick I use with understanding the UN system is that whenever you see something from the UN, it's either going to be one of three animals. It's either going to be a political animal, or it's going to be an expert animal, or it's going to be a secretariat animal. The political is the General Assembly and the Human Rights Committee and the Security Council. They are ambassadors representing their countries in a political forum. They ultimately adopt the sorts of standards we're talking about here today, like a parliament would adopt a law, but they are acting in their political interests. The experts are those who are appointed because of their expertise by the system. So we have treaty bodies here, which are the committees that oversee the application of treaties, and we're very fortunate to have Professor Lee here with us today. But we also have special procedures, just like the Special Rapporteur on DPRK, Madame Salmon and others. And we also have commissions of inquiry and fact-finding missions. The treaty bodies and the special procedures are relevant to courts because, as we'll see in a minute, the treaty bodies provide a form of jurisprudence for national courts, a form of guidance for courts. Special rapporteurs can also be used by courts. The findings or the views, the studies by special rapporteurs can also be used by courts. Fact-finding missions less so at the moment. The Secretariat, the third animal, that's me and Tim. We're Secretariat people, we're the people who support the system. But I have to say, increasingly, at least for our office, we are being tasked with independent-like functions to undertake certain types of inquiries and so forth. And that's a little bit what my work here in Seoul is about. For the courts, we're interested in, as I said, the treaties and the declarations and the resolutions that the political bodies adopt, and they can be of increasing importance. A resolution of the Security Council is binding on Korea as a state, but also, as Tim's mentioned already, the persuasive character of what treaty bodies in Geneva say is very relevant for courts at the national level. The treaty bodies that we'll look at, they do a number of things. These are the committees that oversee the application of treaties which ROK has ratified. They look at reports anywhere between 2 to 5 years. They provide recommendations to Korea. They provide things that we call general guidance. For example, on the right to health, they will publish what we call a general comment, which is something like maybe 20, 30 pages explaining what the committee thinks about what that right, which is often just 2 lines in a treaty, what that right means. And all of the treaty bodies, every single one of them, has an individual complaints mechanism. So individuals can bring cases to the committees, and that jurisprudence, I put it in inverted commas because there's many judges here today, those decisions on those individual cases are also very relevant for national courts. I'd also mention that there's a function that's rarely used, which is the inquiry function, but it's increasingly used, where treaty bodies can establish and inquire on a systemic issue in a country. So, for example, CEDAW, the Women's Rights Committee, had an inquiry on the access to sexual and reproductive rights and birth control in the Philippines, for example. ROK, Korea, South Korea. I have to say ROK because I work for the UN. ROK has ratified 7 of the 9 core human rights treaties. The 2 you haven't ratified are the Convention on Migrant Workers, as far as I know, and also the Convention on Enforced Disappearances. These conventions are binding on ROK as a state, as a matter of international law. Today, I would like to talk about CESC. And again, Professor Lee is with us here today, but I want to talk about CESC because it is the convention that's closest to labour rights, but it also has some peculiarities which I think courts in ROK need to know about. Now, labour rights go through all the conventions, yeah? CESC looks at things like right to work and so forth, but you also have the right to form trade unions under the ICCPR, the Civil and Political Rights Covenant. You also have in CEDAW provisions on equal pay for equal work. You also have in CRPD, the Disability Rights Convention, you have articles on accessibility of places of work. But today, I just wanted to mention CESC, which the ROK ratified 30 years ago. Economic, Social and Cultural Rights Convention looks at things like food, education, work, shelter, and so forth. What's important to know is that CESC, which is Economic, Social and Cultural Rights, and the ICCPR, which is the Civil and Political Rights Covenant, were adopted separately, and they followed 2 very different train tracks. The Economic, Social and Cultural Rights regime lagged far behind the Civil and Political Rights regime in terms of adoptions, in terms of setting up the committee, in terms of jurisprudence. People were more comfortable with civil and political rights than they were with economic, social and cultural rights. More comfortable with torture, arbitrary detention, the right to vote, for example. There was also a significant political aspect to it, which was the Cold War, which I'll leave you to read up about. But ultimately, in the last 30 years, we've seen the fleshing out, the much greater understanding of what economic, social and cultural rights are all about. Sorry, the one exception to what I've just said is labour rights under the ILO. The ILO had a very established system from a long way back, and that was one exception. But generally, the other economic, social and cultural rights lagged far behind. That's why you probably hear so much about it now. It's not that it wasn't supposed to be there. At the end of the Second World War, you had the Americans, Roosevelt trumpeting the freedom from fear and the freedom from want, meaning the freedom from need. But that got caught up in Cold War politics. To understand some things about CESC, which I think is important for judges here and all those practicing in courts here. The first thing is, I've just talked about civil and political rights and economic, social and cultural rights. They are independent, indivisible, interdependent, universal and interrelated. Tim mentioned it, I think. They are supposed to be together, but unfortunately they followed these 2 train tracks for about 50 years, but now more than ever we see how interdependent they are. There was a sense that things like the right to health were not justiciable, meaning a court could not pronounce on them. They were issues of state policy only. And the other thing with the SCR was that they were seen to be rights that cost money, yeah? Right to food means you've got to buy food. Stopping torture means you don't do anything, you just don't torture people. But even that's not true, we know now, yeah? Getting rid of torture in a country doesn't involve doing nothing, it involves training police, it involves constructing appropriate places for detention and so forth. So my point is that these 2 this sort of way of seeing the world has broken down, and so it should, because that's not the way in which the international human rights architecture was set up. But there are still some peculiar things about economic, social and cultural rights which we need to be aware of, particularly in courts. The first one is, more than civil and political rights, more than them, economic and social rights, like the right to work, have both positive and negative obligations. Or some people call them dual freedoms, or some people call them protect and fulfill. The point is that the state has an obligation to not interfere, yeah? Under the right to housing, it has the obligation to not forcibly evict you from your house. But it also has the obligation, if you don't have a house, to provide you with basic shelter. So it actually has the obligation to do nothing and to do something. Even, for example, the right to life, the committee has said very clearly that the right to life goes beyond the duty just to protect the life, just to make sure that you don't arbitrarily lose your life at the hands of security forces or whatever, but that you have a life with dignity. So the government has an obligation under the right to life to do something, to proactively protect you. The second point about ESCR I wanted to mention is the concept of progressive realisation. States, when they ratify CESC, undertake to take steps, I've put them on the, no, maybe I don't have it there, to take steps individually and with international assistance to the maximum of its available resources with a view to achieving the progressive realisation of the right. So the point is that the right to not be, the prohibition of torture, states can respect immediately by not torturing people, subject to what I said before. But for example, the right to housing, what does that mean? And this was the language that they came up when they drafted the covenant. And this is where there is a huge amount of, first of all, jurisprudence on this from in many countries. And secondly, it's also where courts have a role. Because at the end of the day, in the jurisprudence we have from Canada and South Africa and the United States and even Australia and other places, the courts have had to look at whether the actions of the government were reasonable. And that is where the big debate lies. What is reasonable? What we know is, under this article, they can't do nothing. They have to take steps. The fact that the words take steps are there means you have to do something. You can't do nothing. Because many governments will say, we would like housing for all of our people, but we just don't have the money. We'll get there. In 50 years, everyone will have a house. The government can say that, but they can't say in 50 years. They have to say, we're starting today by addressing the needs of those most vulnerable, and we have to be doing something. And we also will have some budget transparency. So you can see that we're putting sufficient resources towards it. The example, the most famous example, is the case of Grootboom in South Africa, where some individuals, families were evicted from a shanty town, and the government said, we're going to evict you, but we're going to build you a new house, and the house will be ready in 2 years. It'll be great. The people said, but we have nowhere to live. We need some shelter. And the government said, no, our obligation under the right to housing is to get you your house. Yeah, and it's progressive realisation and maximum available resources. So we're getting there, and progressively, you will get your house in 2 years. The court said, no, that's not what it means. The court says these people need basic shelter now, and you have to prioritise these people. You can't say, well, but all of our money is going to building 3-bedroom houses. We don't have money to put to emergency shelter. You say, no, that's not the way in which this works. You have to prioritise the most vulnerable. That's where courts get involved in economic, social and cultural rights. There's many more cases. There's also cases where where the government has said absolutely, the courts have said the government is doing the right thing. There was a case in Canada where a political party and the government said, we're going to address the gender pay gap, which is a big issue in the Republic of Korea, I know. And they said, we're going to issue we're going to fix the gender pay gap. There was an economic crisis, and they said, not just yet. We know we said we'd do it, but we'll do it in a couple of years. And in that case, the court in Canada, it was in Newfoundland, said yes, they have an obligation to do it, not just because they committed to doing it, but they have an obligation under the covenant to do it. But the financial crisis has to be taken into account by the court in working out what's reasonable and what's not. So I think for judges and practitioners in courts in Korea, these things are coming down the track. You will be having to face these. The committee, I want to mention just briefly what the committee is, and again, Professor Lee is here. The committee has looked at Korea a few years ago, 2017, and Sorry, before I go to that, I want to go back to one thing. The committee itself has also given some ideas about what reasonableness is, what test of reasonableness you have for the government progressively fulfilling a right. And you won't be surprised that they have said things like the committee will see whether the government has been non-discriminatory in its action. For example, if it says we're going to have universal right to health, but not for non-citizens, they come last. We want our citizens get it first. It should be based on need rather than status. The committee has said there should be a time frame. It should be promulgated by law. It should be subject to be able to be challenged in the courts. All these sorts of things, and I can provide the reference, which makes sense. Now, in many countries, for example, my own country, Australia, the courts are very nervous about getting involved in government policy. It's like you don't get involved in it at all, you just read the law and that's it. In other countries, particularly India, where they have a very strong tradition of social direction and the courts can actually direct the government policy on social matters, they've gone a lot further on these issues. But it's not that some countries have the obligation and others don't. All countries have the obligations that I'm talking about. The committee looked at ROK back in 2017. It raised a few issues, business and human rights. It raised this issue of maximum available resources. There was a sense that the committee, on business and human rights, the committee felt that there was not enough legal framework regulating businesses in Korea and Korean businesses operating abroad. The government responded to that and came back. It responded specifically on the remedy to the damage caused by the humidifier disinfectant scandal that you all know about. But since then, it has also said that it's moving on other laws to make sure that that companies and corporations are held to account. Maximum available resources, the committee was extremely concerned about the very, quote, the very low level of public social spending as a percentage of gross domestic product here, and the lack of accountability for public services. On workers' rights, the committee was concerned, had a number of concerns. It was concerned about abusive forms of employment, particularly long-term temporary contracts that didn't fully protect workers' rights. It was concerned about protections for non-citizens in work, and it was concerned about different standards applied to those working, for example, in agriculture and fisheries. It also had some concerns about non-discrimination, and I won't get into it, but the non-discrimination law story here in the Republic of Korea is ongoing to this day. If you're a judge sitting in a court in Korea, or if you're a practitioner or a lawyer, maybe even more so if you're a lawyer, it's very important to be aware of what can help you in your case before the courts here in South Korea. I've listed on the screen there a few of the essentially guidance notes, what we call general comments of the committee, which talk about what wherein the committee explains what it means on very specific rights. These are not binding on the state. Maybe Professor can speak about that a bit, but it's a long story. They're not binding like conventional obligations, but they are highly, highly, highly persuasive. In the International Court of Justice, Judge Diallo said, although the court is in no way obliged to model its interpretation of the covenant on that of the committee, it believes that it should ascribe great weight to the interpretations adopted by this independent body. So that's the ICJ has said, you national courts should be paying attention to these guidance. The role of the judiciary in implementing international human rights. Korea is, I think, a monist system, but behaves as a dualist system. It is a system that formally says once we ratify, they're directly applicable, but it appears that the country moves ahead and adopts legislation to make them applicable. I don't actually know the answer to that, and I'm putting it out there, but that's what I've read. There was an excellent paper produced by JPRI on these issues, which was the one that was mentioned, which was really excellent. But whether it's monist or dualist, the courts are entitled to use conventional rights in their decisions. I've put some of the ways in which the courts can use this, the direct or indirect application, directly if it's monist. If the convention has not been incorporated locally, then I think you can still use indirect application, I think. That's a fairly controversial, maybe. Developing an understanding of rights, affording remedies in cases of clear violations. And the last point, providing decisions on test cases that can lead to systemic and institutional change. The idea of human rights is that we don't all end up in court one day. The idea of rights is that the problems are fixed by the duty bearer, by the state, be it the executive, the judiciary, or the legislative branch, that they're fixed before we get to that. And one of the ways of doing that is to take on board test cases, which happens in many, many other countries. The treatment of the covenant in the courts are okay. So what happened was when the committee had said to the government, listen, you're not really applying the covenant here compared to other countries, essentially. And the government came back and said, well, yes, we are. And that here's some examples of cases up there. I won't go through them because they're all in Korea's report to the committee. But what's very interesting is this issue of knowledge of the covenant and application of the covenant, in particular knowledge of the covenant amongst the judiciary, has been an issue with the committee, between Korea and the committee. It's come up, and that has, I expect, has spurred what's happened here as JPRI has had a process to look at how, educating judges, but also trying to understand how human rights have been used locally. And then this fantastic report from earlier this year. Back this last 13 years ago, in 2009, the committee expressed concern that the covenant had not been fully incorporated into the domestic law of Korea, and it was concerned about knowledge here. The government has responded to the incorporation point by saying, well, in our constitution, Article 37 says, freedoms and rights of citizens shall not be neglected on the grounds that they are not enumerated in the constitution. That struck me. When I read that, I wasn't quite sure what that means. It said, your rights aren't constrained just because they're not written in our constitution. Well, that begs the question, where are they if they're not in the constitution? On what can you rely to see what the extent of rights are? And I humbly submit that it would be international law and the obligations that Korea has freely ratified by ratifying these treaties. I will finish there. The last thing I'll just mention very quickly is this issue of a rights-based approach. Human rights is not criminal law, it's not administrative law. In many countries, lawyers aren't used to dealing with human rights because they're not one of the traditional branches of law in many countries. It's not about, yes, it's not criminal law or administrative law, it's about a relationship between the individual and the state. The judiciary has a role as part of the state to further a human rights culture in the country. And part of the way it can do that is some of the things I've put on the screen here. We talk about rights holders and duty bearers, yeah? Who has the right to what, and who has the responsibility to provide, to respect, protect and fulfill that right. That's very important before courts because often judges will have to decide whether you have, at least in the common law system, standing, yeah? Whether you have the right to be before the court. If that's framed in human rights terms as a rights holder and a duty bearer, I think that will help further a culture of human rights in the country. Judicial processes and remedies have a key role to play at every stage not just in compensating. Sorry, human rights have a role to play at every stage. So, as you know, there's procedural issues. If the person before the court doesn't speak Korean, they have a right to interpretation. That's a human rights issue. Yeah? These sorts of procedural issues are key for making sure that the rights of that individual are respected beyond what the case is about or whether they get a remedy or so forth. So again, to cast those in terms of human rights, I think would also promote a human rights culture in this country. Judiciaries can also promote effective implementation programs. This comes back to what I said at the beginning, which is talking about the judiciary looking at government programs. I don't know what the situation in the Republic of Korea is. If a judge started saying, and I direct the minister to appear here tomorrow and tell me about this budget, I'm not sure if that works under your system here. In some countries it does. But if the courts are going to get involved in that sort of endeavour here in Korea, then I strongly suggest that it be based on your international human rights obligations. Thank you very much.
Thank you very much, Mr. Heenan. Personally, I'm so impressed with his presentation because when I was in the court, I made an interpretation of our Article 6 and 37 of our Constitution as you presented. But unfortunately, I was in the minority. But I hope with this conference, the nowadays minority will be the majority of the future. And unfortunately, we are running out of time, so I'd like to invite Professor Song to address any comments and questions as a panelist. And please keep your comments within 8 minutes, please.
Thank you. I'll try, but feel free to cut me off if I go over. But I would like to start with a happy news update, which is that the ROK decided just a few days ago to ratify the Convention on Enforced Disappearances. So we're now just one shy of the 9. But I will focus on some broad framing conceptual considerations that I hope will be relevant to the broader topics of this session. And just starting at the most abstract level, it's a fact about international law that, and international human rights law, including labor standards as expressed in international human rights law, that the implementation of this body of law domestically need not, as a matter of legal or logical necessity, be through domestic law. It could be through non-legal means as well. And of course, it's an unsurprising fact that domestic legal implementation is very rarely sufficient for satisfactory implementation. That said, there are important functions that law in particular serves that make it often practically necessary that there's some amount of implementation through domestic legal means rather than just through non-legal means, which include, among other things, a public affirmation in a kind of a formal register of the standards at stake, content specification that can happen often only through legal measures, including legislation, the establishment of procedures for resolving conflicts and disagreements about the meaning and implementation of these international standards domestically, procedures which have the requisite authority and legitimacy that we can expect from legal procedures. And also mechanisms that have also this kind of authority and legitimacy for enforcement. Now that's at the level of legal implementation. It's a further question whether legal implementation through the judiciary is a wise idea. And here again, there's no legal or logical necessity, and obviously judicial implementation efforts are often insufficient for the full realization of human rights standards domestically. And here I think there's also reason to believe that often in many conditions it's both desirable and practically necessary to resort to or utilize judicial mechanisms for the implementation of international human rights law. But it's also important to maybe investigate research, and this might be a helpful research topic or area for the JPRI, when and why this happens, that it turns out to be the case that judicial legal implementation of IHRL is desirable or practically necessary. That is, under what conditions can the judiciary help rather than hinder the domestic implementation of international human rights law? And I'm just going to briefly highlight a set of non-exhaustive set of conditions that seems to be relevant in the research, in particular the empirical research on this question. And one is that the structure and content of judicial review in that particular jurisdiction matters. So, for instance, questions that have been raised already, the status of international human rights law treaties and non-treaty standards in domestic courts vis-a-vis domestic law and different kinds and tiers of domestic law. In particular, the authority of courts to review legislative and administrative decisions. So Mr. Heenan made brief reference to this point. So different countries allow for different kinds and strengths of judicial review, and the outcomes of judicial review can be different. So some countries will allow for things like individual remedies, other countries will allow for more structural options that can lead to broader changes in the law. And these can be, these kinds of variables can be important in helping us understand whether courts can actually structurally, by their structure within the government and the constitutional structure of the country, can actually play an effective or meaningful role in implementing international human rights standards. The second set of conditions involves the role of judges. So it's not necessary at all for judges to actually be sympathetic to the project of international human rights law, but it does seem necessary that judges who have the role of implementing human rights law have an adequate understanding of international human rights law and also more broadly international law, including things like, and this is also a point that just came up in Mr. Heenan's presentation, kind of a research literacy in how international standards emerge, what kind of significance different bits and sources of law have. So for instance, an understanding of the role and authority and the importance of treaty bodies and what they do, for instance, is something that a lot of domestic judges who focused only on domestic law, I think, don't quite understand accurately. There is, I think, a broader question in the background here about what kind of role Korea can play with respect to international human rights law. And here I said leader versus follower. I don't think maybe that's the most sanguine pair of labels, but perhaps something like how proactive is Korea and different actors within Korea, such as the judiciary? How proactive are these actors going to be in the emergence and setting and construction of international standards in human rights? Or are they more going to be more defensive and passive and more focused on, say, deflecting responsibility? So that's a broader question in the background here, it seems. And then finally, there's a whole set of questions about which there is in fact, quite a bit of recent emerging research in the social sciences, including law, about the empirical effects of attempts or projects of implementing international human rights law and standards through judicial means. And here, the question is whether even when judges decide competently and in good faith, there may be certain consequences to judicial means of implementation, such that maybe court decisions or the strategy of pursuing implementation through courts may not always have the positive effects that you might want them to have. So for instance, there was a mention of the recent recognition of the justiciability of social rights in various countries in Mr. Heenan's presentation. There's some amount of empirical research that argues, it's not uncontroversial, there's contention about this, but that argues that a lot of these models of constitutional review of social rights have unfortunate distributive effects in that they benefit middle class and upper middle class plaintiffs. And this can depend partly on the kinds of remedies that are available. So if the court focuses on individual remedies rather than structural changes, then it can have beneficial effects disproportionately to those who can afford to bring court cases, for instance. So this is one question. Another set of issues about which there's a lot of research in domestic civil rights contexts involves the political dynamics of, I'm almost done, this is my last slide, the political dynamics of controversial judicial decisions. So the most dramatic cases come from the US, which has very strong judicial review. So there's a lot of research about whether Roe v. Wade created backlash. There's a lot of commentary now about Dobbs v. Jackson and the effects on the US midterm elections recently. So these are all questions that they don't directly issue in policy recommendations, and they may also not be appropriate for judges to take into active consideration in their role ethics as judges. But they do seem to be important monitoring variables that are worth researching. So that was just, that was just a non-exhaustive list. So the conclusion is that it seems that the judiciary's role in human rights implementation, that there is a role as one potentially helpful avenue among hopefully many avenues. But insofar as it's important to keep this avenue open, it's also important to create and sustain the conditions for judicial efficacy and utility, and the kinds of questions that I mentioned were just examples of things that we might look into to address this question, to address this issue. Thank you. Thanks.
Thank you, Professor Song. Please give an applause. Thank you very much for your very impressive intervention. And now the floor is yours, Professor Lee.
Thank you very much, Mr. Chair, and good afternoon, everyone. And I'd like to discuss especially the two parts. The first, the role of international human rights law in the judiciary, and the second part is the role of the court, especially in the context of economic and social cultural rights. Thank you very much, Professor Song. Okay, so as to the role of international human rights law, first, let's look at the Article 6, Paragraph 1 of the Constitution. Already, Mr. Meyer and also Mr. Heenan mentioned our Constitution, Article 6, Paragraph 1. So according to this article, the treaties concluded by the Republic of Korea has the same effect as the domestic laws of the Republic of Korea. The question is, what is the legal status of international human rights treaties ratified ROK? Because of the values and the norms enshrined by international human rights treaties, there are different views. One view is international human rights treaties ratified by the ROK must have the equivalent status to the Constitution. That is one view. And that might be marginal. More prevalent view is that the legal status of international human rights treaties is equivalent to laws. So in this context, okay, so what's the role of international human rights law in the court? So first, international human rights law must be directly applied by the courts, at least. Maybe in the context of constitutional court, it might not be the case, but at the very least, lower courts, the international human rights treaties ratified the government has the same effect of domestic laws, so it can be directly applied by the courts. And also, at all levels of courts, including constitutional court, the international human rights law should be used as an interpretive guide to relevant domestic law by the courts. And it is consistent with our obligation under international human rights law. And also, according to that, the courts must consider what would be the purpose and object of international human rights treaties ratified ROK, and when the court interprets domestic laws relevant to the international human rights standards, court must look at international human rights law as an interpretive guide, and which includes not only the provisions of all the covenants and conventions, but also, as Mr. Meyer and also Heenan mentioned, comments adopted by the treaty bodies and also decisions adopted by the committees. And second, I would like to mention that, especially in the context of economic and social rights, what would be the role of the judiciary? I would like to ask you to pay attention to general comment number 9 by the Committee on Economic, Social, and Cultural Rights, which is about the domestic application of the covenant, because it discusses the role of a court, the role of the judiciary. So here, the committee stresses that what is important is the state has to enable individuals to seek enforcement of their rights before national courts and tribunals. Although we have international mechanisms which monitors the implementation of international human rights obligations of states, but that is supplementary. So what is important is we have to have effective national remedies. And Committee on Economic, Social, and Cultural Rights also mentions that the court must respect, surely, the respective competencies of various branches of government, executives and also Parliament, National Assembly. But it is appropriate to acknowledge that courts are generally already involved in a considerable range of matters which have important resource implications. Why they say that? Because when it comes to economic and social rights, the courts tend to be reluctant to engage with those cases because it has resource implications, allocation of budgets. But the committee stresses that already courts are involved in those cases. So the committee wants that the adoption of rigid classification, division of economic, social, and cultural rights on one hand and civil and political rights on the other hand. And these kind of rigid classification, and these rigid classification may put economic, social, and cultural rights beyond the reach of the courts, and as a result, it may drastically curtail the capacity of the courts to protect the rights of the most vulnerable and disadvantaged groups in society. Of course, the judiciary is not the only institution can hold the state accountable and provide a remedy for economic and social rights. It's not the only institution, as Professor Song already mentioned. It can be a helpful avenue, one helpful avenue. Nonetheless, what is important is the judicial review of social rights can serve the function of directing attention to the reality faced by people living in poverty and in vulnerable situations. Normally, in general, they may not very well adequately represented in the political process. So that is one of the important functions of judicial review of social rights. And another one is judicial review of social rights can also, if well designed, and facilitate the deliberations about the justifiability of the state action for the realization of social rights, because they can provide an avenue to deliver on specific data on laws, policies, budgets, whether they are reasonable or not, whether they are really, making progressive realization for economic and social rights. And I see more and more these days in Korea, there is growing interest among judges in international human rights law, which is very hopeful and positive. So I'd like to see more dialogues between judges at the national level and also international human rights law and those who are working at the international human rights mechanism, so that in this process, I would like to see more constructive competition and dialogue with a view to developing further international human rights law. Thank you very much.
Thank you, Professor Lee. Thanks to the brief and concise presentation of two panelists, we are following the schedule now. So I can give just 3 or 4, 5 minutes to speakers. Do you have any comments or any more details about the intervention of the panelists, or any more comments? Mr. Meyer?
Thank you. No, we're over time, so very briefly. No, I think they were fantastic presentations because hopefully we're all pushing in the same direction. It shows that human rights is extremely important, but it also shows that it can be very sensitive. So if it's badly handled, it can also be damaging. And we know in many countries where it hasn't been addressed appropriately at the beginning, it's set the cause back many years. So I think this sort of opportunity to think and reflect and share is perfect to make sure that Korea advances. It is already advanced, but advances more on the right road. I don't have any comments. Thank you.
Yes, thank you. Well, thank you very much for the very interesting observations that we just listened to. It made me think of a question I was asked to a good number of years ago here in Korea by the then Minister of Justice. She asked me basically only one question. She said the Committee on Freedom of Association, which of course Korea was certainly at the time very much engaged with, and which the government really felt challenged with. And she said, the recommendations of the Committee on Freedom of Association, are they binding or are they not legally binding? And I said, with all due respect, Minister, I don't think that's the right question. The idea again being, of course you can answer the question from a strict legal perspective. And from a strict legal perspective, you're going to say, no, they're not legally binding. But if you restrict your view on that, you miss the bigger point, and that is precisely when you work, and I think James said it, and I'm very happy. We're working in an area around call it social justice, call it realization of economic, social, and cultural rights. That is progressive realization. In these terms, you cannot think binary. It is not yes or no. These are, and I think the courts do have a role to play there, and they can play. And I was very happy to what one of the speakers spoke about distributive effects. Absolutely, but the courts can have, and they can use international human rights law in order to point to certain structural difficulties that the government then can take up for further consideration. And let me just conclude with one example that actually very recently led to a ratification of Germany by the Maternity Protection Convention. It was a decision of the Constitutional Court in 2003, where, and I see my colleague nodding, he will maybe come back to it tomorrow, but the decision by the Constitutional Court had basically asked the question, the government had wanted to introduce a system of mandatory insurance, maternity protection insurance for small companies, but not for big companies. And on closer analysis, the Constitutional Court said, well, but hang on a second, this is a form of indirect discrimination, because it will, in effect, make it more difficult for the bigger companies to take decisions in terms of recruiting women. So it may indirectly present an obstacle to the... So here you have an example of the Constitutional Court actually pointing to a structural obstacle, not just an individual violation, but a structural obstacle that then the government had to carry forward. And as I said, I'm not going to go into further detail, but as I said, it led the government, the German government, to take a decision that eventually led to the ratification of the up-to-date standards that the ILO has on the topic, which is the Maternity Protection Convention. So thank you very much for these insights.
Thank you so much. Time is running out, so we do not have enough time to have a full discussion. But fortunately, we will have a final plenary session tomorrow. So we may continue this discussion at this final stage. And now we have to take some time to refresh yourselves with tea and coffees. And we will have, this is 17, about a 20 minutes break, and we'll gather here at 4:40. Thank you.
Thanks for the inspiring presentations and all panelists for the lively discussion. This brings us to the end of the first session. Please give a big round of applause to all participants. So from now on, we'll have a 20 minutes break. So we are running about 20 minutes behind the schedule. So we will begin the session number 2 at 4:40. So please take your seats by 4:40. Until then, please enjoy your break. Thank you. Welcome back, everyone. I hope you enjoyed your break. Before we begin session number 2, I would like to remind online participants to submit their questions in YouTube comment section during the conference. If you have any questions for the speakers, please leave a message. And there is also a real-time viewing certification event going on. Please see the More from YouTube section for further information. We'll now commence session number 2. Our topic for this session is Interpretation and Application of International Human Rights Treaties in Courts. This session will be moderated again by Mr. Il-Won Gang, a former Justice of Constitutional Court of Constitutional Court of Korea. Please welcome him with a big round of applause. Mr. Gang, the floor is yours.
Thank you again. Welcome back to the conference. This session, we also have 2 speakers and 2 panelists. We are just slightly behind the schedule, so I also jump into the conference directly. Let me introduce 2 speakers and 2 panelists first. The first speaker is Mr. Javier Bourdonnais. He is ILO coordinator. Mr. Bourdonnais served as International Labor Standards Specialist at the ILO office for the Andean countries. He is currently head of unit and coordinator of collective bargaining conventions at the Freedom of Association branch of the ILO. He is also a member of the Center for Comparative Labor and Social Security Law of the University of Bordeaux. Please welcome Mr. Bourdonnais with a big applause. The next speaker is Ms. Rafaela Kuntz. Ms. Kuntz is a junior fellow at the Collegium Helveticum, right, in Zurich. Her award-winning PhD thesis explored the interaction between domestic courts and the European and the international courts of human rights. Please give Ms. Kuntz big and warm applause. We have 2 panelists, Ms. Hye-young Lee and Judge Tae-young Jang. Ms. Lee is an adjunct professor at Ewha Law School. She worked for the UN Libya Inquiry Commission and as a visiting professor at the International Criminal Court's Trial Division. Visiting professional, not professor. She has also served as a director or board member of the Korean Society of International Law. Please give a big applause to Ms. Lee. And the final panelist is Judge Jang. He obtained a master's degree in international law from Seoul National University and completed the doctoral course in international law at the same university. Before he appointed as a judge in 2015, he worked as a lawyer at Kim and Jang for 3 years. Please give him also a big applause. Now we'll start the second session. At first, Mr. Javier Bourdonnais will make a speech on the interpretation and application of international labor standards in courts. Mr. Bourdonnais, you have 30 minutes. Floor is yours.
Thank you so much, and it is a real pleasure and honor to be part of this important event, especially because it shows the strong commitment of the Judicial Policy Research Institute and the Judiciary of Korea at large with respect to international human rights law and international labor standards. So I'm deeply and really very, very happy to be here and to be part of that panel with distinguished colleagues and distinguished judges. And it is also a great pleasure because the conference seems to be very timely. A few months after the entry into force of important ILO conventions in the Republic of Korea, Convention 29, Convention 87, and Convention 98, So for the ILO, of course, it is extremely important and very, very interesting to have this exchange with you to see which changes will bring the ratification of Convention 87 and 98, and what will be the role of the judiciary in implementing these important conventions. So my presentation will actually be the result of the collaboration between the ILO and in particular its training center in Turin with the judiciaries of many member countries. And as a result of the many trainings carried out by the ILO with the judiciaries of our member countries, we were able to collect information about judicial practice, about the use of international labor standards. So I will make reference to some cases from other countries. And when doing so, of course, I will do so bearing in mind that these cases have taken place in space. These examples are necessarily applicable everywhere, but still it can be, we think, a source for reflection for the members of courts of other countries. So actually what is quite interesting, if we look at the relationship between domestic courts and international labor standards, it's the fact that for the last 30 or 40 years, there have been a significant change. When I entered the ILO, it was a little bit more than 20 years ago, I was looking at the books on international labor standards, and there was a very limited reference to the judicial use of international labor law and the international labor standards. I remember, for instance, a book from a remarkable scholar, Mrs. Virginia Leary. It was a book written in 1982 about this subject, about the subject of the judicial use of international labor law. Well, the book was very interesting and is still very, very interesting. But the cases that were being examined in that book were very few, very, very few. And if I think about another important book about international labor standards, a treaty by Mr. Nicholas Valtikos, this book made, once again, very little reference to this subject, because at that time, I think the last version of that book was published in 1995, there were very, very few examples of judicial use of international labor standards. 25 or 30 years later, the panorama has significantly changed. There are now we have many cases of jurisprudence using international labor standards, both from a quantitative and qualitative point of view. Things have radically changed. If you look at the ILO website, you will find a specific page when you have a database about a series of domestic court cases using international labor standards. In this database, you have, I think, something like 60 countries that are part of the database. But more importantly than the quantitative aspect, what is important is the qualitative aspect, because, of course, using international labor standards, I mean, the fact that the courts use international labor standards is not an end in itself. What matters is whether the use of these standards will make a difference or not. And in many cases, it makes a difference. It makes a big difference. And here I would like to give already a few examples on some specific situations where, in some countries, having recourse to international labor standards is key to ensure a significant evolution of domestic labor laws. I think a first area is when domestic courts are referring to international labor standards to enlarge the scope of workers who are covered by labor rights. Because in some situations, one will observe that the scope of the labor legislation may be narrower than the scope of international labor conventions. So, for instance, we have some cases from different countries where Article 2 of Convention 87 that mentions that sets that all workers without distinction whatsoever should be able to create their union or join a union. So this important Article 2 has been used by some Supreme or constitutional courts to enlarge the scope of the categories of workers that are actually benefiting from this right to associate. For instance, there is a very interesting case from Canada concerning agricultural workers. There are some other cases from Latin America about public workers in which the courts, based on Article 2 of Convention 87, were able to enlarge the scope of application of freedom of association rights. There is also, for instance, a quite recent case from Colombia where what I am mentioning is applied to non-standard workers and self-employed workers. So there is this, let's say, this added value of international labor standards in the sense that especially the fundamental conventions have a very broad personal scope. Another situation also where we can see that domestic courts are using international labor standards is to ensure that the protection granted to fundamental rights is an effective one. So we see a series of cases where some Supreme or constitutional courts have been able to use ILO conventions, ILO recommendations, the work of the ILO supervisory bodies to better protect workers subject to discrimination, ensuring, for instance, that when some workers have been subject or victims of discrimination, the compensation that is granted is not only an economic one, but is also a compensation that makes sure that the situation, the discriminatory situation, is eliminated. So I could go again with many other examples, but I wanted already to mention them to show that there is an added value in referring to judicially refer to international labor standards, and as a result, to ensure that there is a substantive evolution of national labor laws. And what I would like to mention here as well, it is, and this is also why perhaps I was mentioning in the introduction that this conference is probably very timely. It is also because we see that there are specific situations where it is especially important for courts to refer to these international sources, especially when there is a change of paradigm that requires the domestic legal order to adapt itself to these new paradigms. So, for instance, when a new constitution is adopted, or, for instance, where important conventions are being ratified. If we look, for instance, at the situation of countries such as South Africa or Spain in past decades, one can see that once these countries have ratified important conventions, such as Convention 87 or 98, some years after this ratification, the Constitutional Court of Spain, the Constitutional Court of South Africa had frequently recourse to international labor standards to make sure that their domestic legal order would fully take into account the content of these ratified conventions. Another reflection here is to reflect a little bit more on what facilitates the fact that in a series of countries there is an increased use of international labor law and an increased use of the ILO sources. And probably here what we see is that the legal mindset of judges is evolving, and a series of prejudices that might have existed in these countries are receding. So here in this slide, you see the use of outdated. Actually, perhaps I would rephrase it, and I would inspire myself from what my colleague Tim de Meyer mentioned in the previous session. And perhaps rather than outdated, I would put too simplistic. Too simplistic. So many of these sentences here are too simplistic. So yeah, it's too simplistic to consider that international law only deals with the relationships between states. Of course, the mere existence of international human rights law shows that international law also deals with, of course, the rights of the persons. Of course, it's too simplistic to consider that international treaties are only binding upon the executive and legislative powers. In the previous session, there were several mentions to this very interesting general observation from the Committee on the Economic and Social and Cultural Rights, which very clearly shows that, of course, the judiciary, as part of the state, has a responsibility, a full responsibility to implement international treaties. And actually, this aspect, the fact that international treaties, of course, also apply to the judiciary, it is also very clear from Convention 87. And here I would like to read a provision of Convention 87, which I think is quite interesting in this respect. If you look at Article 8 of Convention 87, the article has two paragraphs. The first paragraph says, in exercising the rights provided for in this convention, workers and employers and their respective organizations, like other persons or organized collectivities, shall respect the law of the land. And then you have a second paragraph that says, the law of the land shall not be such as to impair, nor shall it be so applied as to impair the guarantees provided for in this convention. So I think this article is very relevant to our today's subject, because of course, in order to respect this convention and in order to respect ILO conventions at large, it is necessary to have a legislation that is in conformity with the convention, but it is equally important, of course, to make sure that this legislation is applied in a manner that is consistent with this convention. Another perhaps too simplistic statement would be to consider that provisions of human rights treaties in general and international labor standards in particular set general principles that are too broad to solve specific disputes. So this is certainly true in many instances, but not necessarily always true. You may, and you certainly have, in the ILO conventions, a series of general principles that are extremely important in order to settle specific disputes. I mentioned a few minutes ago a series of cases where courts used, for instance, Article 2 of Convention 87, which is very broad, it's true, its content is very broad. All workers and employers, without any distinction whatsoever, should be able to create a union or join a union. It's a general statement, but still extremely important, and as I have mentioned, in a series of countries, this has made possible the settlement of disputes, and it has made possible to ensure that some categories of workers were recognized the right to organize. Another statement that is probably too simplistic. Only self-executive provisions of international treaties may be applied by courts, while programmatic provisions have to be taken care of by the legislative and executive powers. So this sentence refers to a quite traditional distinction concerning international law. I think it has been mentioned during the first panel. And yes, okay, there are some provisions that recognize some rights to the persons or to the workers, and that seem to be specific enough to be applied directly. For instance, Mr. De Meyer was mentioning the Convention on Maternity Protection. Certainly in this convention, Convention 183, there are some probably self-executive provisions. For instance, the provision that sets that a minimum of 14 weeks of maternity leave should be granted to women, while there are some other provisions that, for instance, request the state to develop a policy, for instance, an employment policy, Convention 122, or to develop a policy to promote equality in employment and occupation, 111. And we understand that the second type of provisions, of course, require a development by legislation, a development by state policy. Nevertheless, one may consider that actually if one look a little bit more carefully the content of international treaties and the content of ILO conventions in particular, one may understand that actually in the same provision you may have some aspects of the provision that are programmatic in nature and some other aspects of the provision that may be directly applicable. Taking into account also that this provision, this international provision, if it is invoked before a court, it will be invoked in a specific dispute where this provision may be used directly or may be used indirectly. So taking into account these different elements, it's a little bit simplistic to consider that, okay, there are some provisions that qualify for judicial use and some other that do not qualify for judicial use. This will probably depend very much on the specific dispute at stake. And here we'll take an example from South Africa, a very interesting example, the Hoffman case. This was a case concerning a person who tried to be part of an air company, to be engaged by an air company, and the person went through all the different steps of the recruitment process, but at the end of the day, that person was not engaged because there was a medical examination, and it appeared that this person was HIV positive. So there was no problems of evidence. It was clear that that person had not been recruited because of his or her HIV status. But the question before the court was to determine whether this person would be granted only an economic compensation or whether that person would be recruited. And interestingly, in that case, the Constitutional Court of South Africa applied this constitution, but it applied this constitution in the light of Convention 111, Article 2, that requires states to adopt a policy aimed at promoting equality in employment and occupation and aimed at eliminating any discrimination in employment and occupation. So what was the reasoning of the court? The reasoning of the court was, okay, what in that specific case, what will make possible to eliminate the discriminatory provision? Will it be an economic compensation or will it be the recruitment of the person? In the context of the South African legal system. And once again, I mention again what I said at the beginning. When I refer to some concrete examples, they take place in a specific legal system. It does not mean that they necessarily can be transposed in their entirety in other legal systems. But in that case, quite interestingly, so the South African court used for interpretative purposes this Article 2 of Convention 111 that is usually considered as a programmatic provision, and it made possible to settle this specific dispute. So as you can see, there are a series of statements that in the past were considered as totally true, that today have been relativized quite a lot. So, and they are not considered to be 100% true, but rather there should be here a much more, stronger, they should be reflected upon in a much more thorough manner. So, we go ahead, and here I would like to spend some more time, even though I see that I do not have so many more minutes, 7 minutes exactly. But this is a very important element of the presentation, and this is an element that was referred to by my colleague Tim. It was also referred to by Mr. Hillen from Office of the High Commissioner on Human Rights. And it is the importance of the reference of the work of the ILO supervisory bodies by domestic courts. So there were some mentions already about these supervisory bodies. I will not enter into details about, I will not describe them in a detailed manner because it would take much more than 6 minutes. But still, I think it is important to be very aware of the fact that legal practitioner, both judges and lawyers, if they really want to apply international labor standards, they really need to have a strong knowledge of these supervisory bodies' comments, because these supervisory bodies' comments will make possible to have a correct understanding of the scope and the meaning of these conventions, and it will be the best manner to ensure that you do not misunderstand or misinterpret these instruments. And actually, there is an increasing number of domestic courts that, when they apply international labor standards, they do not only apply ILO conventions or ILO recommendations, but they also take into account the reading and the interpretation of these instruments by the ILO supervisory bodies. So let's take some examples. For instance, some courts have made important rulings concerning the issue of equal remuneration. Convention 100, equal remuneration between men and women for work of equal value. But what does it mean, equal remuneration for work of equal value? Here you may have, you may end up with very different interpretations. But here, very important, the work of the ILO Committee of Experts on the Application of Conventions and Recommendation, that based on Article 3 of Convention 100, helps us to understand that this concept of equal remuneration for work of equal value requires to evaluate the value of different jobs, in the sense that the only manner to tackle discrimination between men and women on the issue of remuneration, it is only possible to do so if we take into account the fact that there is very often segregation in the labor market, that some professions are mostly occupied by men and some other mostly occupied by women, and the only manner to tackle the existing discriminations will consist of evaluating the respective value of these different jobs. So this is, I think, quite interesting examples where courts, such as courts in India, courts in Germany or in Italy, were able to use the work of the ILO supervisory bodies in order to interpret not only the content of ILO Convention 100, but actually also the provisions of their domestic legislation or constitutions in order to ensure that their interpretation of their national law would be fully consistent with the content of international labor conventions. I could give here many more examples about how the use of these supervisory bodies' comments are being used also to assess the conventionality or the constitutionality of certain provisions of domestic law, but for time's reasons, I will go ahead. And here mention that, and I think it is a point that has been mentioned already during the previous panel, but it is a very important one. The fact that there is a judicial reference, the fact that there is a judicial reference to the work of the supervisory bodies does not presuppose that they are considered as legally binding by the domestic courts. I think that Mr. Heenan mentioned it very clearly. He said, well, look, there are many cases where courts recognize the highly persuasive nature of the supervisory body's comments, and this makes possible for them to incorporate the reasoning of these supervisory bodies in their legal reasoning. And this makes possible for them to use these supervisory bodies' comments to frame their own decisions. And this is certainly a very interesting manner to ensure consistency between domestic law and international labor law. Okay, so time is running out. I would like just to mention that if we try to complement this overview of the use of international labor standards by domestic courts, we see that, and it has already been mentioned in the previous panel, there are different types of roles that international labor standards can play in the settlement of disputes. It can be used to directly resolve the dispute. It can be used to interpret a domestic provision on the basis of international labor law. It can be used as a source of inspiration in the establishment of jurisprudential principles. I would like also to mention that if we have a closer look at the direct use of international labor standards, of course, what may, let's say, a lot of attention may be paid on the last part of this slide, those cases where a court will invalidate a domestic provision that would be directly contrary to international law. But you have also some other situations where, for instance, an international labor provision will be used to fill a gap in domestic law, or will be used to go beyond or to a domestic provision that would be less favorable to the workers than the international one, without necessarily having to consider unconstitutional or to consider that a domestic provision should be eliminated from the domestic legislation. So my time is running out. I would like to conclude by mentioning a few final elements. When judges and when tribunals soundly take into account international labor standards, in particular the ratified conventions, they contribute to strengthen the rule of law, and they contribute to legal certainty in their domestic legal order. And this may resonate with the mentions that were made in the previous panel about Article 6 of your Constitution, So certainly, by taking on board ratified international labor conventions, domestic courts contribute to the application of your constitution. And so they certainly contribute in a significant manner to the rule of law. But as it has been said, in order to do so in a sound manner, it is extremely important for courts to be aware and to be versed on the work of the ILO supervisory body's comments, because this is the best manner to make sure that courts correctly understand and correctly interpret international labor standards. This requires, in turn, the strengthening of an international labor law culture for judges and legal practitioners. And this is why we are so happy with this event, because we see it as a continuum in the very significant efforts carried out by the Korean judiciary for a series of years now to enhance this international labor standards culture of judges and legal practitioners. And of course, you can count with the ILO support in this respect. Thank you so much.
Thank you very much for your wonderful presentation. I believe all the legal practitioners of Korea should have heard his wonderful presentation, because it is a duty of legal practitioners to understand the international labor standards and raise these issues in the courtroom. But unfortunately, the Korean labor lawyers usually rely on the domestic law rather than the international standards. So I will urge my colleagues to listen to this excellent presentation of Mr. Baudonnet. Thank you so much. Now I'd like to invite Ms. Kunz to the floor. She will make a presentation on the human rights courts before domestic courts. You have 30 minutes. Floor is yours.
Wonderful. Thank you so much. And here come the slides. First of all, thanks also from my side for the invitation. It's really a great honor and pleasure to be here. I did a lot of work on judicial dialogue, on interactions, on interactions between courts, so I'm particularly pleased about this type of exchange and interaction, so thank you very much. I am not a labor lawyer, as you will see from my presentation. I have done my PhD about the role of domestic courts in the implementation of the judgments of the Inter-American Court of Human Rights and the European Court of Human Rights, and I have equally written, the book was in German, I have equally written a paper in English that is available open access, so basically the presentation today is largely based on the paper in case you are interested in some more details. Both have been published in 2020 already. Now, you might wonder, why am I focusing on courts, on international courts, and not so much we talk about today about application of human rights treaties. Why am I focusing on human rights courts? As you know, both the European and the Inter-American system have a permanent court. These are Articles 68 and Articles 46 of the conventions. They both issue binding judgments, and as you all know, of course, it really were very much these two courts that brought life into these conventions, basically that really brought really the meaning to these conventions. The Inter-American courts already since '79, and the European Court, as you know, since Protocol 11, since 1998. There is, of course, today also the African Court of Human and People's Rights. However, its first judgment was only in 2009. Today, of course, I would also look at the African Court. However, when I started my work, really, the jurisprudence of the two regional courts, the Inter-American and the European Court, were already extremely rich. So there was really a lot of judicial interaction in these two systems, basically, and that's what sparked my attention. again here, the idea really the law is what the judges say it is. That's why I decided to focus not on the conventions, not on the application of the conventions in courts, but really the application of the case law and on the judgments of these two courts. And what I was interested in doing was really analysis on the ground, so to say. So I really wanted to see how domestic courts really engage with the judgments of these two courts. I worked with the databases, international law and domestic courts, so I claim that this analysis was empirical in some ways. What I would like to do today, I would like first in a descriptive part, I would like to distinguish between three phases I argue that we can observe. We can observe a first phase of judicial interaction where there was a big reluctance on the side of domestic courts to interact with international law, with international human rights law. Then we had a phases of compliance partnerships. And thirdly, I would like to argue that maybe we are witnessing today a certain attitude of domestic courts or a certain shift to an attitude of contestation in certain domestic courts, both in the European and the inter-American systems. And then in a second step, I would like to already maybe turn to the debate, to the discussion, discussing what role domestic courts should play today at the intersection of legal orders. But now first to the descriptive part. As I said, I think we first can observe phases of reluctance. We have heard this already today. The traditional perspective very much was that the executive was the main actor, of course, on the international plane, also the addressee of international judgments. Benvenisti wrote in 1993, a much-cited article. He spoke of judicial timidity back then, and he argued that domestic courts were very much deferential towards their governments. He argued that this was due to a lack of knowledge. We have heard that already today too, but on the other hand, of course, also out of a sense of protection of sovereignty and of national interests. And you might all be familiar with the famous avoidance doctrines. Of course, courts employed the doctrine of self-executing treaties. We have heard that already several times today. Or again, also the political question doctrines. There are further doctrines. So these were very much doctrines used by courts, I would say, still in the 90s. And as you all know, of course, human rights law is one of the first areas where this started to shift, of course, because the traditional view, as we have heard just before, was too simplistic and just simply not adequate in human rights law. Gradually, courts moved to a sort of compliance partnership with the human rights courts. And here also in the literature there was already, since quite some time, there was quite some debate. We have heard that also by my colleague just before. There was, since many years, domestic courts were basically seen as important enforcers of international law. We all know that in the international arena there is a lack of central enforcement mechanisms, so domestic courts were really seen as important complements here for putting international law in action. The dédoublement fonctionnel by Georges Sell is, of course, dates already from much before that courts both have a hat, so to say, in the domestic arena, but also in the international arena. And as Noel Kemper wrote in 2011, domestic courts are important guardians of the international rule of law. And there was also this idea, of course, that this would actually not weaken the domestic judiciary, but rather strengthen this engagement with international law, with human rights law, and that it would help the domestic judiciary strengthen itself against the executive, but also, of course, standing up for liberal democracy. So that's basically the theory. The Institut de Droit International already wrote in 1993 in a resolution that in order to attain within each state a correct application of international law through its own methods of interpretation within each state, it is appropriate to strengthen the independence of national courts in relation to the executive and to promote better knowledge of international law by such courts. So that was really the idea that courts can be very important agents in international law, important enforcers of international law, against the background of the reluctance until then of courts to apply international law. Now let's look a little bit into the cases, what I observed in my case analysis. And so the case law really shows that domestic courts have indeed become very important compliance partners of the human rights courts in both systems. So there are important differences. The inter-American system is more hierarchical than the European system, as you might know. And domestic courts there seem to be also more open towards the Inter-American Court of Human Rights. In many constitutions in the inter-American system, for example, the Inter-American Convention has also constitutional rank, so there is greater openness, we can say, in general, but also in Europe we can witness that domestic courts have really become very important compliance partners of the European Court of Human Rights. So all of this you can find in detail in the paper, but what courts do basically is they adjust their own interpretation, for example, to the interpretation of the two regional courts. They are even willing to reopen final judicial decisions, even if this is not foreseen legally in the domestic order sometimes, in some cases. And of course also the judicial review, the constitutional review. Many courts are also willing to act as legislators, so to say, and to strike down legislation that is contrary to the jurisprudence of the regional human rights courts. However, what is also very important is that this enforcement is not a mechanical enforcement. It is very important that since early years already many courts basically make clear that they are not strictly bound basically by the judgments, that they are only willing to take into account the jurisprudence, and since early years already they indicate certain limits also to their willingness basically to follow the human rights courts. And of course in Europe a very known example is the Gergely judgment by the German Constitutional Court from the year 2004, in which it exactly established this taking into account doctrine. And I would like to zoom in now a little bit more on this. And the court made several important statements in this judgment, and one of the first statement basically is about the value of the case law of the European Court of Human Rights, so not about concrete judgments, but really the broad case law. And here the German Constitutional Court stated that the text of the Convention and the case law of the European Court of Human Rights serve on the level of constitutional law as guides to interpretation in determining the content and scope of fundamental rights and constitutional of the basic law. So also in Germany, basically, the European Convention has not the rank of the Constitution, but it serves here, apparently, including the jurisprudence of the court as a guide for the interpretation of the Constitution, and it also serves to strike down legislation in some cases. Then the court also makes a statement about the value of judgments to which Germany is a party. So it distinguishes here between the case law more broadly and really judgments to which Germany is a party. And here it says that if in concrete application proceedings in which the Federal Republic of Germany is involved, the European Convention of Human Rights establishes that there has been a violation of the Convention, and if this is a continuing violation, the decision of the European Court of Human Rights must be taken into account in the domestic sphere. So basically the Constitutional Court makes clear that it feels bound by the European Court of Human Rights, however, only to take into account the judgments and not necessarily to give effect to it in the exact terms. Now, what does this obligation to take into account mean? It also makes that, of course, a little bit more clear by stating that the responsible authorities or courts must discernibly consider the decision and, if necessary, justify understandably why they nevertheless do not follow the international law interpretation of the law. So they must take into account discernibly, and if they do not follow, they must deliver a justification, basically. So this is the position by the German Constitutional Court taken in 2004. Now, as I have already mentioned, I think we can today witness a third phase after reluctance compliance partnerships, now maybe a phase of more contestation, of more friction between the human rights courts and domestic courts. So there is really over the last years an increasing number of judgments in which domestic courts really actively, very explicitly started to oppose the human rights courts. And this can be called a sort of gatekeeping role that they are taking. Some people call this judicial dialogue. I'm not sure judicial dialogue is really the right word for this type of exchange. Another word that has been used is principled resistance. So really the idea to oppose really for principled reasons, so to say. And it's important again to note here that limits have already played a role since a long time. For example, the Austrian Constitutional Court already in 1987 has made very clear that the Constitution is a limit to the implementation of judgments of the European Court of Human Rights. But I still think that that the quality we witness in recent years is really a different one. Exactly. So I have several examples here. You are probably all, of course, familiar with the Russian Constitutional Court, the important judgment of 2015, in which it basically established a right to object to the European Court of Human Rights. And very importantly, it did rely on the German Constitutional Court and also the Italian Constitutional Court. It relied on the Gergely judgment that I just explained. So there also a sort of judicial dialogue and interaction, actually. Then a second example is the Italian Constitutional Court, also from 2015. The Italian Constitutional Court used to be extremely open towards the European Court of Human Rights. It has even been criticized to be too open. And then in 2015, it kind of made a little turnaround, and it stated that Italian courts are no passive recipients of an interpretive command issued elsewhere in the form of a court ruling. A third example is the Argentinian Supreme Court from 2017, and also this case is extremely important because also the Argentinian Supreme Court used to be one of the most important allies actually of the Inter-American Court of Human Rights. And in this judgment, the Fontevecchia judgment, also the Argentinian court basically relied on fundamental principles of public law that needs to be respected in order to basically enforce a judgment of the Inter-American Court. And finally, a last example, this again is maybe not such a surprising example, is a judgment by the Polish Constitutional Court from last year, in which it basically introduced the ultra vires doctrine, which is more known from the European Union context, basically to the European Convention system. So again, we have a really mixed bag in a way. On the one hand, courts where maybe the independence of the judiciary is questionable, where it's maybe not so surprising that there is a certain resistance or tendency or attempts to undermine the human rights courts. But on the other hand, we really also have courts that used to be very open and strong allies to the human rights courts that also seem to be taking kind of a different position over the last years. So what is very important is that when we take a closer look at these cases, at first sight they seem of course very alarming, and that's also the reaction often in scholarship, of course. And when we look at them more closely, it's very important to see that they testify of more friction, but they are not always actual clashes. And with clashes, I actually mean leading really to non-compliance with a binding judgment. So the fact that a domestic court really decides not to declare unconstitutional, for example, a judgment of one of the regional courts is still really rare. And in most of the cases, basically, it's more the question of the interpretation of the case law more broadly. So I think that's really a very important distinction to make. And so the word backlash, of course, is also familiar to all of you. There is this big debate about a backlash against the human rights courts, backlash against international law more broadly. I think we need to be cautious using this in this context. I think we can witness a changing attitude of courts. However, I also think in some cases it's really also because simply the legal reality really has become much more complex for domestic courts. There are massively, on a quantitative level, massively more judgments domestic courts are faced with nowadays. The law has really become more complex in a way. So there is definitely also the potential in a way for more conflict. And on the other hand, the human rights courts, of course, have also qualitatively really restricted the leeway for domestic courts. They started to order more and more concrete measures, for example, and they have also kind of expanded the erga omnes scope of the conventions. So I would say that the legal situation in a way really also has become more complex. We should be careful when talking directly about a backlash against the courts. Then this is a little bit provocative in this context, I would say, but I think it's still important to mention also that there indeed are cases simply where domestic courts find themselves in a situation of a dilemma. And I think again, I will come to a very interesting example. So again, it's very important to mention domestic courts, of course, are important agents on the international plane. They are guardians of the international rule of law, but of course, on the other hand, they also remain answerable to the dictates of applicable domestic law. I think here I cite Rosalind Higgins. So this can, of course, really lead to a dilemma for domestic courts. And I think one really important example or nice example for that is the case of Bulacio versus Argentina. In this case, the Inter-American Court had ordered that Argentina needed to reopen criminal proceedings despite a statutory limitation in place in Argentina. And the Supreme Court of Argentina answered in this case. There is a paradox in the fact that it is only possible to comply with the duties imposed on the Argentinian state by the international human rights jurisdiction by severely restricting the rights of defense and the right to pronouncement within a reasonable period of time as guaranteed to the accused by the Argentinian Constitution and the Inter-American Convention on Human Rights. So not only a clash actually between the Constitution and the Inter-American Convention, but even kind of an intra-conventional clash itself. I'm not saying that these cases are frequent, but I think they do exist. So now, and I think I will be done actually early, turning to my last point. This, of course, very much raises the question which role domestic courts should play today at the intersection of legal orders in this really complex legal reality, I would say. My opinion is that there are really very important normative reasons that domestic courts should be compliance partners of the human rights course. As we have heard, of course, human rights judgments are not at all purely interstate issues. They involve individuals, they involve persons directly. This would lead kind of to a very asymmetrical situation between the international and the domestic arena if individuals can go before an international court but then are not able to enforce that judgment domestically. Domestic courts very often, that's also important, really are the only enforcement avenue basically for individuals. And then, of course, we can discuss possible limits to the role of courts. Someone also mentioned separation of powers. There might be other limits. Of course, domestic courts might not in all and every situation be the right avenue to implement a human rights judgment, but in some cases, I think they do have a very important role to play. However, I also think that there are also important normative reasons really against blind obedience, so to say. So I also think there might be reasons in rare cases when domestic courts might not be willing to follow a human rights judgment. Karen Knopp already in 2002 has written that in this kind of binary view between binding and non-binding, enforcement, non-enforcement, domestic courts are reduced to bureaucrats. this is, of course, probably not a vision the domestic judiciary likes to have of itself, and this is probably kind of provocative, but there is a growing number of voices also in the literature arguing that disobedience in really rare cases, kind of as an ultima ratio, might have a legitimizing effect to avoid injustices that might result basically from international judgments. Very importantly, of course, it is a slippery slope, I completely agree, as we have seen with the Russian Constitutional Court citing other courts, but I do still think that this does not exclude per se that this might in some cases also have a good effect. What I do find very problematic on the other side is that domestic courts really start to kind of systematically control the jurisprudence of the human rights courts. Many courts have started to develop even criteria, for example, to evaluate the jurisprudence of the human rights courts before they apply them. The Italian Constitutional Court is an example. Also, the German Constitutional Court is now going a little bit in this direction. So, for example, the Italian Constitutional Court argues that Italian courts should only follow consolidated case law, for example, by the European Court of Human Rights, and criteria to establish whether a jurisprudence is consolidated is whether it is a judgment by the Grand Chamber and not simply by the Chamber. Whether there are dissenting opinions, for example. So the fact that there are dissenting opinions is a sign for the Italian court that a jurisprudence is not consolidated. And it also names the creativity of jurisprudence. So basically when the European court develops a new jurisprudence, then also the Italian court now considers this to be not consolidated and will probably actually not follow it anymore. So, which role for the domestic judiciary? To conclude, I think domestic courts are neither only compliance partners, nor should they be seen as gatekeepers only. In a way, today they are mediators between legal orders, which is, of course, a very complex task. And I think that an open and flexible stance towards both international and national law basically is better suited to cope with the very complex legal reality than really systematically judging anew basically on judgments that have already been decided by the human rights courts. And with this, I finish early, 5 minutes.
Thank you so much. Thanks to Ms. Kunz's clear and concise presentation. We are now on time. Thank you so much. And I'm so impressed with her great presentation. I should read her books. I totally agree with her presentation. Thank you so much. Now I invite two panelists. We will hear the intervention of two panelists. We have each panelist have 8 minutes. So please, the first I'd like to invite professional researcher Lee. Please, the floor is yours.
Yeah, thank you very much, Justice. I really appreciate Mr. Botonet and Dr. Kunz for your very informative presentations. And it's just a great pleasure to share my thoughts on this very important topic. As you can see on the screen, my discussion for today will proceed in the following order. To enrich the implications of the presentations given by Mr. Botonet and Dr. Kunz, I'd like to briefly introduce the situation of Korean courts in interpreting and applying human rights treaties. In particular, I'll provide a quantitative and qualitative analysis of court judgment that apply the 7 core human rights treaties that Korea ratified. And lastly, I will also ask questions in relation to their presentations. For background information, Korea ratified the 7 core human rights treaties, including International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights. And under the Constitution of Korea, as ratified, these human rights treaties are automatically incorporated into Korean domestic laws and thus can be directly applied in court. And in order to see the actual normative status of human rights treaties in Korean courts, I conducted research on all court judgments rendered between 1990 and 2019 by Korean courts that applied those 7 core human rights treaties. And as a part of quantitative analysis, I calculated statistics on the number of court judgments by year and by treaty. And as a result, it was noticed that in Korean court, there has been a noticeable increase in the number of court judgments that applied the 7 core human rights treaties over the last 30 years. That is, the human rights treaties were only applied in 12 judgments in the 1990s, but in 705 judgments in the 2000s, and in 2,468 judgments in the 2010s. This shows that Korea is not an exception to the global phenomenon, as Mr. Botonet also presented. An increasing number of domestic courts are applying human rights treaties. In addition, it was also noticed that the types of human rights treaties applied in the court judgment have diversified over the last 30 years, as you can see on the screen. This shows that the normative status and significance of human rights treaties have increased in Korean courts over time. I also compiled data on the acceptance and rejection rates of specific claims based on human rights treaties in court judgment in order to see whether human rights treaties actually contributed to providing actual remedies to victims of human rights. As a result, it was noticed that while there was a significant difference in the acceptance rate depending on the issue, but the overall acceptance rate for claims based on human rights treaties increased remarkably over the last 30 years. In particular, if you see the graph on the screen, while the acceptance rate in conscientious objection cases have slightly increased over time, acceptance rates for all other types of cases will increase more than double. And following that, my research also examined the court reasonings that led to different conclusions. And it was noted that when it comes to resolving conflicts between human rights treaties and domestic laws, judgments that accepted human rights treaty-based claims resolved the conflict by interpreting domestic laws in accordance with international legal obligations under the human rights treaties. In contrast, judgments that rejected human rights treaty-based claims avoided conflicts by interpreting human rights treaties in accordance with domestic laws rather than the other way around. So, and in regards to interpretation and application of human rights treaties, judgments that accepted tended to apply teleological or effective or revolutionary or dynamic interpretation principles and interpreted human rights treaties with respect for authorities of treaty bodies' interpretation. However, judgments that accepted human rights treaty-based claims also had limitations in that they used the human rights treaty somehow in a decorative manner to reinforce the conclusion that was already made based on domestic laws. And in contrast, judgments that rejected human rights treaty-based claims generally applied the very strict literal interpretation principle, showed less respect for treaty bodies' interpretation, and interpreted the human rights treaties provisions in accordance with domestic jurisprudence for similar domestic laws. So, what conclusions can be drawn from this research? If we only look at the quantitative analysis, the normative status of human rights treaties in Korean court judgment might be seen as improving. However, the qualitative analysis of the court reasonings showed us that Korean courts tended to base their decisions on domestic laws due to their familiarity. Because domestic judges haven't necessarily had enough opportunity to familiarize themselves with human rights treaty, it has been very difficult to incorporate universally accepted interpretations of human rights treaties domestically. So this conclusion has very important policy implications, I believe, because it highlights the need for judicial policy, assisting judges in becoming more familiar with human rights treaties. For example, it would be helpful to incorporate resources for treaty interpretation into the data search system in Korean courts and make them accessible and available to judges. And furthermore, it is also recommended that courts expand and strengthen opportunities for judges to receive training in the application of human rights treaties. Although this conclusion was only derived from a study of court judgment that applied 7 core human rights treaties, I believe it could also shed some light on Korean court's general approach to interpreting and applying all other human rights treaties, including ILO conventions. So next, I would like to ask some questions on 2 topics to Mr. Bodonet first about his presentation. And actually, I very appreciate Mr. Bodonet's highlighting how prejudices that prevented domestic courts from applying human rights treaties in their commonly understood meanings have become outdated. And Mr. Bodonet also described very properly how courts can use non-binding instruments for interpretation. I generally agree with all of Mr. Bodonet's explanations, but I would like to emphasize that the difference between ratified treaties and non-binding instruments should be fully acknowledged, despite the utility of a non-binding instrument. The reason why I'm saying this is not to minimize the utility of a non-binding instrument, but to emphasize the legal effect of ratified treaties. Because under the Korean Constitution, ratified treaties are directly incorporated into Korean domestic laws. Nonetheless, ratified treaties have frequently been treated as mere useful reference rather than as laws in Korean court judgment. So as such, if Mr. Bodonet could elaborate more about the difference between the legal effect of ratified treaty and non-binding instrument, even for interpretive purpose in court, that would be appreciated. I have also few more questions about the role of domestic courts in resolving conflict between human rights treaties and national legislation. Actually, we've already talked about this over the email, but I'd like to ask this question again for general audience. And there are 2 types of conflict that could occur in domestic courts. The first type of conflicts occur when there is a clear textual conflict between domestic law and human rights treaty that cannot be resolved through interpretation. It is commonly understood in Korea to resolve such type of a textual conflict between norms of the same rank by applying lex posterior or lex specialis rules. However, considering the special nature of human rights treaties and also considering the fact that ratified treaties remain fully legally binding no matter what, I doubt whether it is appropriate to use the lex posterior or lex specialis principles to resolve a conflict between human rights treaties and domestic legislation. And as such, I'd like to ask Mr. Bodonet if you could elaborate on your thoughts on more desirable ways to resolve the first type of conflict. That would be appreciated. And also in relation to that, it would be also appreciated if you could address the question of whether human rights treaties, which have lower status than the Constitution, in the domestic legal order, such as those in Korea, could be used for constitutional interpretation. Although there are differing views about the status or rank of ratified treaties in domestic legal order in Korea, but it seems that majority views agree that treaties have a lower status, at least than the Constitution. So that's the reason why I'm asking this question. And next, as the second type of conflict, when treaty bodies and Korean courts interpret treaty differently, and when they have different perspectives on whether relevant domestic provisions are in accordance with treaty obligations, judges may have to decide which body's interpretation prevails. So in such a situation, I'd like to ask Mr. Bodonet. Actually, you already a little bit mentioned in your presentation, but I would like to elaborate more about ask you to elaborate more about what makes the non-binding instrument interpretation of the treaty bodies, including ILO supervisory bodies, so authoritative. And my last question is for Dr. Kunz. I especially agree with Dr. Kunz's approach and suggestion that we need to overcome traditional binary thinking of domestic courts only as either gatekeeper or compliance partner. And instead, we need to see domestic courts as important parts of a broader network of global community of courts. And domestic courts also need to consider themselves as a mediator between different legal orders rather than guardians of a particular legal order. But my final question is motivated by the fact that Korean courts are situated in different normative environment than our European or American counterparts. Firstly, there is no regional human rights court for Korea or Asia-Pacific states. While states in Europe, the Americas, and Africa have established regional human rights courts that deliver binding judgment against member states, Asia-Pacific is the only region that does not have a regional mechanism for human rights protection. And in addition, Dr. Kunz presented many interesting rulings from domestic courts in European and American states, but it appears that many of those states have a constitution that are friendlier to human rights treaties than the Korean constitution. So for example, the constitution of Argentina and Brazil explicitly give human rights treaties constitutional hierarchy. And the constitution of France and Germany gives treaties and international law precedence over domestic legislation. And the constitution of Italy and the Netherlands require that all domestic law conform to international law. And the Spanish constitution requires the provision relating to constitutionally recognized fundamental rights and liberties be interpreted in accordance with international human rights law. However, the constitution of Korea only provides that treaties and international law shall have the same effect as Korean domestic laws. As such, my last question for Dr. Kunz is how your research on how regional human rights court judgments were used in domestic courts in Europe and the Americas could shed some light on the Korean court's approach to interpreting and applying human rights treaty, given the different normative background in which the Korean courts are situated. This brings me to the end of my discussion. Thanks for listening.
Thank you, Dr. Lee. We will hear the answers after the intervention of Judge Zhang, and we are again running out of time, so please, Judge Zhang, keep your time within 8 minutes. Floor is yours.
먼저 훌륭한
Well, first of all, I would like to thank Mr. Bourdonnais and Dr. Kunz for their excellent presentations. I respect you for these presentations. It was an opportunity for me to once again think about the role of domestic courts. I would like to mention that in the domestic courts of the Republic of Korea, international law and domestic law have no difference. We don't have indirect applications, but rather direct applications. And we do not even have to think about self-executing. Along these lines, we have heard from the two presentations, and we can see that our thoughts are quite relevant. If we take a look at some of the judgments in the Republic of Korea, although it's not common, we do have receding prejudices, as has been pointed out by our two speakers. In some of the judgments, we have seen indirect applications or have used international law as a supplementary use for reverse consistent interpretation, or sometimes they put an importance on domestic law or the unique situation of Korea. However, amongst the judges of the Republic of Korea, we see that these prejudices are receding, as Mr. Baudot has mentioned. Compared to the past, we have seen an advancement in the interpretation and implementation of the International Human Rights Treaty, in particular the conscientious objection of military service. And for the judgment of this case, we have seen the direct application of international treaties, and general comment number 22 on the individual communication, as well as the concluding observations, have been used as main reasons for judgment. The judgment also refer to the Charter of Fundamental Rights of the European Union as well as the Living Instrument Doctrine. This judgment is being introduced by the UN as an innovative judgment. Next, I wanted to talk about validity, especially within Mr. Baudonnet's presentation. It talked about how international human rights treaties can invalidate some of the domestic regulations, but this is related to the Constitution of Korea, and due to the time constraint, I will have to skip over this part. But in the Republic of Korea, I would like to emphasize that based on international treaties and the enforcement of the executive body, we are bound by these treaties. Next, let me talk about the application of international treaties. As you have mentioned in your presentations, Korean domestic courts are applying international treaties directly, and the issue here could be non-self-executing. Well, non-self-executing at times could make courts hesitant in directly implementing international treaties. And so I think we have to think about whether this is a wrong way of utilizing jurisprudence in not directly applying international treaties. And so I do believe that we do not need to differentiate self-executing and non-self-executing in the Korean courts. In our regular report, we have already emphasized on numerous occasions that international treaties are being directly implemented in the domestic courts. Let me now talk about interpretation, just some points that domestic courts should keep in mind. Well, we should not have rigid interpretations only focusing on domestic laws and unique Korean situations. In particular, we have overly emphasized the divide between the two Koreas and also the national security issue as a way to not interpret the international laws according to international standards, but that is in the past. And human rights is no longer a domestic issue. It is surely an international issue. And so we should not overemphasize the specific situations of individual countries. I believe that if we overly emphasize the uniqueness of the South Korean situation, it would be not abiding by our duties for international law. Next, let's talk about some practical issues in interpretation. For the domestic courts, how much of a documentation from the international courts should we be considering in domestic courts? Mr. Baudonnet mentioned that we need to have close observation of the recommendations and general comments of the international committees, and surely we are considering them. At times, we also research the decisions by the European Human Rights Court. As we continue to talk about during session 1 and 2, concerning the general comments, it seems that we do not have great weight or considerable persuasive authority or high rank, but it's very difficult to say that they are binding legally, although we believe that it has considerable persuasive authority. We have to consider the Vienna Convention on the Law of Treaties for this. I think we have to emphasize the important parts due to the time constraint. So Article 31 and 32 of the Vienna Convention on the Law of Treaties should be reflected. We need to take a look at opinions, reviews, general comments, all of the soft laws for the civil and political rights should not be an all or nothing issue. We need to consider the overall spectrum as they influence the domestic decisions. Well, next, let's talk about the opinions of the Convention for the Protection of Human Rights and Fundamental Freedoms. Well, Dr. Kunz actually mentioned the word dilemma related to this. And her presentation was centered around the European Human Rights Court. But for the Korean situation, I would like to talk about the issue of the opinion of the International Covenant on Civil and Political Rights. So the committee actually recognized this civil and political right of an individual, but the domestic court did not recognize this. This was related to the conscientious objection to military service. And at the end of these judgments, there should be a remedy which should include compensation, the change in domestic laws, as well as a notification of the general opinion. Related to the domestic law, remedies such as compensation is included. There are some cases where remedies are not executed by domestic courts, and so individuals sometimes ask the court for such remedies to be executed, but with the exception of one single case, none of the remedies have been executed. It may be related to resistance or prejudice, but it's actually more of a structural issue in Korea, because for the individuals, they actually have a judgment that finds them guilty in domestic courts, and that is where the dilemma comes from. So this individual, if we recognize that they should receive the remedy stated by the international courts, then that may actually be going against the original domestic court decision in finding that individual guilty. So it's been about 20 years since we have done this, but we have a special law that enables the remedies to be executed, but it actually is not passed by the parliament yet. Thank you very much for your attention.
Thank you very much, Judge Jang. I'm so pleased to hear that the incumbent judge agree with the opinions of the speakers. I'm so happy to hear that. And because we are running out of time, I will wrap up this session after hearing the answers from the speakers of the questions of Dr. Lee. And because of time limits, please answer very briefly, maybe within 3 minutes. And Mr. Bourdonnais, please.
Thank you so much, and thank you to the two panelists for their extremely interesting and insightful presentations and comments. So 3 minutes, I think I have at least 3 questions, so I don't know if I will be able to respect the time limit, but I will try. I understand that, Madam Judge, you first made a point about the importance of making sure that ratified treaties are fully taken into account by domestic courts, and of course I cannot. I can only agree with you, and there is of course a clear responsibility for the state and its different powers, including the judiciary, to apply international treaties. So when it comes to the interpretation of domestic legislation, so clearly when a treaty has been ratified or an ILO convention has been ratified, the judiciary should make sure that there is an interpretation that is in conformity with the ratified convention. And I understand, speaking of course under your control, I understand that this will make sure that you correctly apply Article 6 of your constitution. But once said that, this does not mean that the judges may not want to have recourse to non-binding instruments, not as an obligation, but as a useful tool to interpret the legislation or to identify a general principle. And here I would like to give an example. So we have conventions, but we have also recommendations, as it was mentioned. And these recommendations, even though they are not binding, they can be extremely useful for the judiciary. Let's think about recommendation 198 about the employment relationship that gives guidelines to member states in order to distinguish which situations should be covered by the legislation on employment relationship and those situations that should be covered by other types of legislation. So using recommendation 198 has been used actually by domestic courts from a series of countries and proved to be extremely useful. Concerning your second question, you were mentioning whether it would be possible to use ILO conventions that may not be recognized a constitutional status to interpret your constitution. So once again, I am of course not a Korean lawyer, but so I'm certainly not the best person to give an opinion on this. But still, I first understood from your presentation and from previous presentations that there is perhaps still some uncertainty about how to interpret Article 6, about whether ratified treaties would be considered as having a constitutional nature, status, or a status that would be similar to domestic legislation, ordinary legislation. But you also mentioned you also mentioned the importance of the Vienna Convention on the law of treaties. I think both of you mentioned the importance of this convention and in particular Articles 26 and 27 about the need to apply in good faith the ratified treaties and the fact that domestic legislation cannot be an excuse for not applying the ratified treaties. So that may also be taken into account when interpreting Article 6. And there is also, I think, an aspect about the substance of the ILO instruments. So if in your constitution you have provisions that refer to some specific rights or some specific principles that are also covered by ILO conventions, as it is, for instance, with respect to freedom of association, collective bargaining, non-discrimination, one may consider that it would be quite natural for judges to make sure that these provisions of your constitution are applied, taking into account the corresponding provisions of ratified international treaties. And this is what many courts do, as you have mentioned in your presentation. And your last question was about what would make the ILO supervisory bodies, what would make their comments so authoritative? So first of all, I would like to recall that under ILO Constitution, Article 37, this is the International Court of Justice that have the authoritative interpretation of the ILO instruments, and in particular the ILO conventions. But still, the ILO, as an institution, has entrusted the ILO supervisory bodies with the responsibility of monitoring the correct application of these conventions. So when a country ratifies an ILO convention, it also accepts that it will be subject to this monitoring. And if we connect this with Article 26 of the Vienna Convention on the law of treaties, that requires states to apply in good faith the ratified treaties, it seems that it makes sense for the states and for their judiciary to take on board the statements and to take on board the comments and criteria from these supervisory bodies, and to at least presume that this is the correct interpretation in order to apply in good faith these conventions. And then there is perhaps another argument. It is less legal, but still perhaps quite important as well. There is the fact that these supervisory bodies, I mean, their only dedication is to examine these standards. And I think that several presentations mentioned the issue of familiarity or non-familiarity with these instruments. So clearly, the ILO supervisory bodies are extremely familiar with these instruments, and so it may make sense to carefully take into account their positions. And the last point, very last point, some of these bodies are tripartite in nature. For instance, the Committee on Freedom of Association. And so their position is a position based on a consensus between the employers, the workers, and the governments at the international level. And this gives, we think, a very special legitimacy to their position. And in an area that is so sensitive as labor law is, the fact that we can count on a consensuated position between the three actors of the world of labor, it also gives, we think, a very special value to the position of these bodies. Thank you so much.
Thank you very much, Dr. Kunz. Now, your floor is yours.
Yes, and I will keep it short. Luckily, we will have a bit more time tomorrow evening. So first of all, thanks for both really interesting questions and remarks. Dr. Lee, I found your quantitative analysis really interesting also. I think that's actually really valuable and should be something we should do more in the future also. However, I also think that it shows, as you showed also, that it's not sufficient. It's necessary maybe, but it's not sufficient, and it's also very important really to look into how then in detail courts really deal actually with each other. And then the unfamiliarity point, maybe this is something we can discuss a little bit more tomorrow. So Benvenisti already in '93 said that he thinks that unfamiliarity with international law is not really the problem. The problem really more is that courts don't want to apply. It's a question of deference towards governments. I don't know, this is maybe something we can discuss more tomorrow. And then just one very brief comment on the question of the legal setting and formalism. So one of the findings of my study basically was that actually you are right, the constitutions are more open maybe than the Korean constitution, but one of my findings really is that the legal setting actually is not what most matters. It's really how courts actually apply it in concrete cases. And to just give one example, you mentioned Brazil and Argentina that both have extremely open constitutions. And for example, Brazil does not at all have a very open stance towards the Inter-American Court. So I think, yes, you are right, it's a factor, but it's definitely not what matters most, I would say. But this is also something we can discuss maybe more tomorrow then.
Thank you very much. It is the fault of moderator to not be able to give the chance to give a floor to engage in this discussion. But as mentioned earlier, we have less plenary session to have a chance to continue these discussions tomorrow. And finally, I'd like to really thank you for all the participants, speakers, and panelists, and all the participants here and in YouTube. Thank you so much. See you tomorrow. Thank you.
Thank you for bringing us a very productive session. Please give a big round of applause to all participants. We have come to the closing of today's conference. On behalf of JPRI, I'd like to extend my sincere gratitude to all of the moderators, speakers, and panelists. I truly appreciate the expertise and the professionalism you brought to this conference. And I would like to thank everyone who came out to the conference today, both in person and online. Also, I would like to remind that the second part of the conference, titled Ratification and Domestic Implementation of the ILO Fundamental Conventions, will be held tomorrow at this location. I wish you a pleasant evening and look forward to seeing you tomorrow morning at 10:30. Thank you.